was unbelievable. The judges used to talk because the judges used to express themselves to actually seek answers. And we, in fact, when judges don't talk, Malas, it's very dangerous because we don't know what.
I always felt when I was a lawyer that, if you have a judge who's quiet, it's a very dangerous thing. You never know what.
You never know. So we can't even clarify what's in his mind. So it's good wherever
the trouble is very often now with this live tweeting, people don't realize that what is said in the court is not what you think about a matter. It's only to elicit the response of the counsel.
And they misinterpret things. So
and ultimately, you look at the holistic perspective of the matter. There may be a little point here against a counsel, a little point there against a counsel. You can never have a 100% case in favor of one party or the other. Those are rare cases.
Right. Lord, that my lord tend to make the lawyer argue additional points, thinking that this might be in the mind of
the enunciation of the law has to be through a dialogue. It can't be any other way.
Sometimes the questions are asked to get the answer, so that we can also know what is.
Absolutely.
Suppose we are in confusion.
Yes, absolutely.
So the first point is the objective material.
Objective material, my lord, which is considered. Second point, the submission of the petitioner that 10th schedule has a direct correlation with the governor's exercise of power under Article 174. And I have to wait. When I say I, my lord, I'm sorry, I represent the Honorable Governor has to wait till the Speaker decides.
So the argument that the 10th schedule has a direct correlation with?
No, that's their argument which I'll deal with.
Yes.
That Governor is not concerned with 10th schedule or the consequences flowing therefrom. That's, my lord, my respectful submission.
You're saying the 10th schedule has a direct relationship with the power of the governor.
Yes.
No, it doesn't have.
It doesn't have the power.
He's dealing with the argument of
it's their argument. Yes, my lords are right. It's their argument.
Right.
And I'm dealing with that argument that governor is not concerned with the consequences contemplated in the 10th schedule. Lord, the other side relied upon, I'm sorry.
Yes.
The other side relied upon.
Third point now.
Yeah, third point, but it is a subcategory of this very point.
But we'll take it as 3.
Your lordships, yes, your lordships would recall the other side relied upon heavily on para 397 of Bomai to show that no, 10th schedule and governor, you cannot say that there is no correlation. But I will point out that that was in a context and completely different context. In fact, on the proposition whether 10th schedule has anything to do with the governor's exercise of power under Article 174, the real judgment is Rameshwar Prasad. I'll read only few paragraphs. I have earmarked and I will not repeat, my lord, any other thing. The next point which the petitioners urged was the governor should have required the my learned friend's side to move a no confidence motion rather than directing a floor test. Lord, next point is, Dr. Singhvi, my lord, raised this point, and in my respectful submission, squarely covered by Shivraj Singh Chauhan, my lord, that power under 174 to conduct floor tests can be exercised only when the government is formed for the first time and not subsequently. Lord, that is dealt with by your lordships, my lord, in Shivraj Singh Chauhan. It was argued in the same zeal, my lord, with which it was argued here, and it is dealt with. And that's a good law, my lord. That's my respectful submission. And last, why did the governor invite Mr. Eknath Shinde and not interacted with the party or the president of the party as to whom should I invite. So these are the propositions, my lord, and I'll be as brief as, my lord, I can be, my lord, under the facts of the case, my lord.
Only 5 propositions.
These are 5
Yes,
propositions.
Six propositions. my
Six.
lord. One is-
Sub-
Lord, so far as the objective facts are concerned, Lord, I have filed a compilation. It's a very short compilation. Documents your lordships have seen, but I have compiled it in one chronological order, my lord.
Which is this document?
Compilation on behalf of the Honorable Governor, my lord, that's the,
Yes.
my lord, I have the physical copies also.
We found it.
There are two documents from your side, Governor LOD with documents and written submissions of Tushar Mehta.
Yes, Lord Governor LOD, my lord.
Yes, we have got that.
Yes, my lord.
Just only 1 second.
And my lord, the original file of the Honorable Governor is present with the responsible representative of the Governor, my lord. If your lordships would like to peruse, but all these documents are supplied to them also. Since, my lord, it was once it fell from, my lord, the Chief Justice of India that we may call for the file of the Governor, therefore it's kept here. And I'll not read, my lord, the documents. It is only, my lord, for...
Sorry, Mehta.
Lord, can I give the physical file?
Oh, sir, oh, इसे open करना. कभी-कभी पेपर नहीं है.
Lord, could your lordship find, I may give the...
LOD, you know? Yes,
LOD.
we got the LOD.
Lord, kindly come to page 1. Lord, this is, your lordships are aware, my lord, there is a concept of legislature party and political party. The legislature party appoints or elects, my lord, Shri Eknath Shinde as the group leader of Shiv Sena legislature party in the legislature.
This is your list of dates, right?
Yes.
Yeah.
My lord, I'm sorry, PDF page 8. I'm sorry, my lord.
PDF page
8.
8.
I'm not taking a losses to the list of dates.
Fair enough.
List of dates are essentially for showing which document is for what purpose.
All right.
I'll show the document itself, my lord, just to save time. Page 8, my lord. It is 25th of November 2019. The Shiv Sena legislature party, meaning all MLAs belonging to Shiv Sena, who are elected under the banner of Shiv Sena, elects Shri Eknath Shinde as the leader of the house, my lord, as we say. They say group leader of Shiv Sena legislature party. And, my lord, this fact is not a fact in dispute. This would have a bearing as to why the governor called Eknath Shinde when the dispute arose first. But I'll come to that little later. I'm just showing the document. Now, my lord, kindly see PDF page 12. Lord, this is annexure B, my lord, of my compilation. Your Lordship gets that, my Lord? Today, my Lord, this is addressed by Sri Eknath Shinde to the Deputy Speaker with a copy to the Governor, my Lords, which your Lordships would find marking of copy at PDF page 13. May I read, my Lord? Today, through media report, it has come to our knowledge that there was a meeting of the members of Shiv Sena Legislature Party called without any notice of the said meeting given to any of us, including existing leader of Shiv Sena Legislature Party. It has come to our knowledge that only 16 MLAs out of 55 MLAs of our legislature party attended the said unauthorized meeting and passed the resolution to remove Sri Eknath Shinde as leader of the Shiv Sena Legislature Party. It is pertinent to note that the said meeting was without any notice and without any quorum and without following the due procedure. We state that 16 out of 55 MLAs could not have appointed a new leader of Shiv Sena Legislature Party in as much as the requirement of even quorum was not met. It has come to our knowledge that Mr. Chaudhary has been unauthorizedly stated to have been appointed as a leader of Shiv Sena Legislative Party. We have today unanimously passed the resolution resolving that the said resolution dated 21st June 22 passed at 12:30 p.m. appointing Sri Ajay Chaudhary is void as being without jurisdiction and the same is my Lord, inoperative. And kindly see, my Lord, PDF page 14. This is the resolution which is signed, my Lord. Your Lordships would find at page 18 onwards by 34 members. Meaning, I'm sorry. Lord, meaning thereby, as on this date, my Lord, that is 21st of June 22, the Honorable Governor was informed that there is no change in the leader of the legislature party and Sri Eknath Shinde continues to be the leader of legislature party in Maharashtra legislature. Lord, thereafter, I'm sorry, my Lord, can I proceed? My Lord, kindly come to PDF page 21.
This resolution is also of the 21st, no?
21st, my Lord, yes. Later sent to the Honorable Speaker and the Honorable Governor on the same day, informing that any unauthorized meeting where 14-15 MLAs may have gathered to change the leader is unauthorized, and Sri Shinde, who was appointed in 2019, continues, and all, my Lord, 34 have signed. Now, my Lord, page 21.
Page
31, I'm 21. On 25th of June 22, Lord, I'll not approximately, exact, I'll give the figure. Lord, 38 MLAs, it contains signature of 38 MLAs, writes to the Honorable Governor that malicious withdrawal of security of our family members have taken place. And there they point out certain, Lord, shocking facts and also produced before the Governor the video clips of national news channels which your Lordships would find at PDF page 22, para 5 bottom. Lord, one leader of the Lord, the party says, let all the MLAs come to the floor of the House. We'll see then these MLAs who have left, they will find it difficult to return and move around in Maharashtra. Then, my Lord, the NDTV clip is produced. Then, my Lord, these are the signatures of I'm sorry, my lord. There are, I'm sorry, my lord. I stand corrected. My learned friend is right. There are not only 38 MLAs belonging to Shiv Sena, and at page 27, they are independent. My lord, there is some other party, small party, my lord, Prahar Janshakti Party. They have 2. So meaning thereby, my lord, 40 and 7 independent. So 47 members of the House, 38, 2 and 7, inform the governor about the threat being administered.
38 MLAs, right?
38 MLAs of Shiv Sena legislature party,
Yes.
2 belonging to one smaller party called Prahar Janshakti Party, and 7 independent MLAs. That this is the threat being given, our securities is withdrawn, and they say that one of the leader, important leader of the party says that let them come here. They won't be able to move around in
This is that letter at page 21.
page 20. And signed, my lord, up to page 28.
So that that composition of those MLAs, just give us again.
Yes, my lord. Kindly, my lord, come to page
38 Shiv Sena.
Yes, no, my lord, 38 Shiv Sena. Yes, lordships are right, my lord. 38
party.
Lord, that your lordships would find the last figure at page 26, PDF 26, 38 Shiv Sena.
Right.
Then at page 27, Prahar Janshakti Party Amdar. Amdar would mean member of Legislative Assembly. My lord, Amdar and Khasdar. Khasdar means
Two
member of
MLAs.
Parliament. My lord, the Chief Justice would be obviously knowing. Then, my lord, page 28. These are Apaksh Amdar. So, independent members. They are 7. So, total 47 members. Pointing out that threats are being administered. So, thereafter, at page 29, the Honorable Governor informs the central government as well as the state government that this is the representation which I have received, and therefore he requested. Lord, kindly see page 29, Lord, the letter addressed to the Home Secretary of the of country, my lord. Unnumbered middle para, my lord, that would be relevant. Your lordship has that, my lord. Your lordship, may I read? Second unnumbered paragraph. I have already issued directions to the state police to provide adequate police protection to the MLAs, their families and homes on an immediate basis. Now please see, despite this, offices and homes of some of the MLAs have been vandalized, with the police being a mute spectator. It is accordingly requested that adequate provision of central security forces be made and kept ready in case required to address the situation. Lord, next page 29, page 30 is a similar letter to the Chief Secretary of the State of Maharashtra. Lord, kindly see the second unnumbered paragraph. I therefore direct you to provide adequate police protection to the MLAs, their families and homes on an immediate basis. Lord, similar letter I'm not reading at page 31 to Additional Chief Secretary, State of Maharashtra, Home Department, that you provide immediate security. Lord, a similar letter at page 32, PDF page 32, addressed to the Director General of Police, State of Maharashtra. Same, my lord, direction that you provide immediate security. I'm not reading it, my lords. Lord, next is, my Lord, page 33, similar letter to the Police Commissioner, Mumbai. Now, my Lord, comes page 34, Bharatiya Janata Party, Maharashtra Vidhi Mandal Paksh, means legislature party of Bharatiya Janata Party, writes a letter dated 28th of June 22. Lord, kindly, my Lord, allow me to place this, my Lord. This was not read, my Lord, by. Lord, this is signed by the leader of the legislature party, Shri Devendra Fadnavis, in the House on behalf of the party, and there is no dispute that he is the leader of the House so far as this party is concerned. I am elected, your lordships can skip first, the election to the Maharashtra am I with your lordships at page
Yes, yes, we are.
34.
1 minute.
The elections to the Maharashtra Legislative Assembly was held on 21st October and the results were declared. Well, then he gives the bifurcation, your lordships have taken note. Shiv Sena had contested the election in pre-poll alliance with the BJP. However, after declaration of results, the Shiv Sena chose to enter into a post-poll alliance with NCP and INC to form Mahavikas Agadi government. The BJP is thus the principal opposition party in Maharashtra Assembly, having 106 members. It appears that over the last 8 to 9 days, there has been an internal strife within the Shiv Sena legislature party. It is common knowledge through widespread media coverage that a majority of Shiv Sena legislature party is feeling that their party's ideology is compromised. It is reliably learned that Shiv Sena legislature party and its leader have clearly indicated to the Chief Minister Sri Thackeray and that they want to end the alliance with NCP and INC. The Chief Minister has thus lost majority in the Assembly. My belief that the Chief Minister Sri Thackeray has lost the majority in the Vidhan Sabha is further reinforced by various news reports circulating in electronic as well as social media, where a group of 39 MLAs of Shiv Sena are seen declaring that they want to exit the unnatural alliance with NCP and INC. The chain of circumstances and events has envisaged in the electronic media and various statements made by the majority group of 39 MLAs, it make it sufficiently clear that Sri Thackeray does not enjoy the majority of the floor of the Vidhan Sabha. I say and submit that there is a wide coverage in the electronic media about the members of Shiv Sena legislature party being threatened by their top leadership, and there have been incidents of attacks on the residences and offices of such members. Further, there appears to be the provocative statements made by the leaders close to the Honorable Chief Minister to incite violence against the members of Shiv Sena legislature party. I submit that the same is being used to browbeat and coerce the aforesaid members to fall in line and to make up for the lost majority of the Chief Minister. I submit that the violence unleashed against the members of Shiv Sena legislature party is at the behest of leaders close to the Honorable Chief Minister. For instance, Shiv Sena Melava in Bombay, some rally or a gathering, Sri so-and-so issued a disturbing threat saying, and my lord, video is attached for the governor to see, which the governor has seen. 40 bodies will arrive from Guwahati and they will be directly sent for postmortem. Lord, this is not denied or disputed on facts before your lordships or before earlier. So Governor, my lord, relied upon it. That's all, my lord, I'm saying. Another instance of a clear threat by Sri so-and-so is where in an interview given to a leading channel, he has clearly stated that the ongoing violence is only a warm-up and that the trailer will come later. He has further stated in the said interview that stones will now be pelted at the MLAs. The said interview can be accessed and the link is given. It's not just ipsi dixits or, my lord, some personal view of any particular individual. Then, my lord, he gives several other links for the governor to see. Lord, this was the material before the governor. Now, my lord, please come to page 38. Lord, this is I'm sorry, this is, my lord, attached. This is the, my lord, attachment to the email, my lord. Your lordships may skip that. Then, my lord, Next is letter dated 28th of June 22. My lord, this has been read and reread, and therefore, my lord, I am not reading it substantially. I'm sorry, my lord, this is not read, my lord, I'm sorry.
What is 38? 38? 37 or 38? That later.
My lord,
That
38.
attachment, what is that attachment?
Yes, my lord, I'll just. Letter of independent MLAs to the governor. I'm sorry, my lord. My lord, the attachment is at next page, my lord.
Please read. What is it?
Yes, allow me to read, my lord. This was not placed by my colleagues, my lord. Request to, this is by the independent MLAs. 7 independent MLAs.
Those who earlier supported.
Yes, my lord. The very same MLAs. They say, request to ask the Honorable Chief Minister to prove the majority in the shortest possible time. We are members of so-and-so. Your lordships can skip, my lord, the statistics. Para 4. However, in past few days, it has become crystal clear that Sri Thackeray, Honorable Chief Minister, does not have a majority in the Assembly. The same was reflected in the recently concluded elections for Rajya Sabha members as well as the elections for seats of Maharashtra Legislative Assembly. Well, this is also another material that he couldn't, my lord, get the people of his, my lord, party elected. The dwindling majority of the incumbent MVA government has been further reduced when more than 38 MLAs of Shiv Sena, who were earlier supporting the Honorable Chief Minister, declared in press as well as social media that they want Shiv Sena to break its unnatural alliance with NCP and INC. Various photographs and videos have been in circulation in the media of Shiv Sena MLAs reaffirming the said claim. The turmoil within the Shiv Sena legislature party and Shiv Sena has raised serious doubts about the Honorable Chief Minister, Sri Thackeray, commanding the support of the majority of members in Maharashtra Legislative Assembly. In short, the events that have unfolded in the past few days in the state of Maharashtra have made it absolutely clear that the current incumbent MVA government led by the Honorable Chief Minister no longer enjoys the majority in the Assembly and therefore does not have any moral, legal, constitutional or democratic right to continue as the Chief Minister of Maharashtra. We have also come to know that Sri Thackeray and his colleagues, with a view to convert the minority into majority, are trying to get certain MLAs of Shiv Sena disqualified by misusing and violating the provisions of anti-defection law. We have already addressed a communication in this regard with our letter dated 24th June to the Deputy Speaker, copy whereof is attached herewith. Your Excellency will agree that in a democratic setup, only a person who enjoys the majority support of the House has a right to continue as the Chief Minister. A person who does not enjoy such majority has no right to continue as the Chief Minister and is obliged to prove his majority on the floor. In view of the matter and keeping in view the established democratic principles, my lord, they seek that immediate floor test be directed. My lord, now your lordships have read this letter, my lord, which is at PDF page 42. This, my lord, is read and reread, whereby the Honorable Governor requests the then Honorable Chief Minister, Sri Thackeray ji, to prove his majority, my lord. I am not reading it, but, my lord, kindly see, my lord, the request, my lord, is a special session, my lord. This is at page 45. Therefore, I'm just showing, my lord, that this was exercise of powers under Article 174, read with 175 too. Therefore, in keeping with the constitutional and democratic values and principles as also the law laid down by the Honorable Supreme Court of India, and in pursuance of the powers conferred under Article 174, read with Article 175(2) of the Constitution, I hereby issue the following directions. A special sessions of Maharashtra Assembly be summoned on 30th June at 11 a.m. and, my lord, other consequential directions. Lord, suffice to say, your lordships have seen, the Honorable Governor relies upon Bomai, Rameshwar Prasad, Shivraj Singh Chauhan, etc., my lord, that floor test is the only test. And the only satisfaction which the governor is supposed to reach at this stage is the satisfaction that floor test is required. He is not supposed to Lord, record a satisfaction that yes, you have lost majority. He doesn't do that.
But he does that. He does that. Governor says, I'm therefore confident that you and your government has lost the trust of the House.
My lord, for
The
the
government is
purpose
in
of,
minority.
yes, my lord, for the purpose of, he is justifying his direction, that now you go and prove it otherwise. That no, you have the trust of the House. My lord, otherwise he would have invited somebody else immediately, my lord, if he would have arrived at that satisfaction, which he could never have arrived at constitutionally. It has to be the satisfaction to call for the floor test. That you go and face the test. This is prima facie material. Material is unimpeachable. Everything is in public domain. The elected people are coming and representing to me in writing. Go and face the floor test. Yes. Yes. Lord, now if that satisfaction is not recorded, that there is a
So really speaking, Mr. Solicitor, the material before the governor was only three things. One, the resolution by 34 MLAs that any change in the leadership of the House is not warranted, that therefore they continue to have reaffirmed that the leadership will be with Eknath Shinde, not with Chaudhary or Gogaule. One. Two, the letters by 47 MLAs about the threat to their security.
For converting minority into majority.
And the third, the letter of the leader of the opposition.
Yes.
That 39 MLAs of the Shiv Sena want to exit the alliance with the BJP, with the INC and the NCP.
Yes, my lord. And saying,
essentially all this correspondence boils down to three aspects, three things basically.
Independent MLAs letter.
Independent MLAs
and the resolutions passed,
and the 34 MLAs.
Resolutions passed by them respectively. Letter is accompanied by resolutions to show that this is not happening for any other reason. This is happening because the chief minister has lost majority and he wants to convert his minority. That's the only thing, my lord, in my respectful submission, the governor is supposed to see. That in fact, he appears to have been reduced into minority, but he can go to the floor of the House. That's the ultimate.
Ultimately, it boils down to this. Suppose there is a policy difference between a group of MLAs within a party.
Yes.
It was on the alliance with the NCP and the INC. Suppose there's a policy difference on whatever aspect, spending funds for a backward region in the state. We don't want this to be done.
Several, yes, sir.
The difference of the MLAs can be on a variety of things. There's a policy difference of a group of MLAs within a party, because governor also says they also don't say that look, we are leaving the party, because the moment they say, because governor also says they also don't say that look, we are leaving the party, because the moment they say that they are incur the 10th schedule. Can the governor merely on that basis say, now I'm of the view that you must prove your trust vote in the, you must go to a floor test.
I'll answer that, my lord. But that, my lord, I would better answer after showing the law on the point, because, my lord, the answer is this, immediate answer is this. The reasons for the dissatisfaction or reasons based upon which the sitting chief minister has lost majority is not the consideration for the governor. That can be a ground for disqualifying them, taking any other action within the party fold, etc. The governor is supposed to only understand, no, my lord, and that's what the law, your lordships have laid down, whether he has lost majority support or not. Whether
two different things, you see. One is whether the governor has material to indicate that, well, that the existing government has lost majority on the floor of the House. Equally, the governor must be conscious of the fact that his very calling for a trust vote may lead to a precipitate loss of majority for the government, because calling for a trust vote may itself be a circumstance which will lead to the toppling of the government.
My lord, I don't think, my lord, with profound respect, my lord, as I understand, the governor, my lord, cannot take that call.
Governors should not really lend their office for effectuating a particular result.
Lord, kindly see, my lord, kindly examine it.
Here, and leader of the opposition writes. Leader of the opposition.
The difficulty is, my lord, my other
leader of the opposition's letter is irrelevant, according to me. The leader of the opposition will always write to the governor, say, look, these people are acting contrary to the constitution, that their policies are anti-people. that is no ground for the governor to act. The independent MLAs who said, or the MLAs who said, my security is under threat, this was not a report under Article 356. He was not saying that the government of the state cannot be carried on in accordance with the dictates of the
That's going to be
Constitution.
my submission, my lord.
So the threat to security cannot be a ground for calling for a trust vote. So both those are out of reckoning. The only thing which survives is the impact of the 34. Because
May I answer that? May I answer that?
34 is something which is because 34 in a party which has 55 MLAs. So
Lord, may I answer that? Lord, first of all, the parameters for Article 356 are different and 174 is
highest what the governor's letter may indicate is that he was of the view that there was a certain dissension within the party on whether to continue with the alliance with the Indian National Congress and the NCP, right? Can that be a ground for the governor to say you call for a trust vote?
Kindly, my lord, and allow me to answer. The governor.
Then you are virtually breaking a party.
Kindly, my lord, the difficulty is, my lord, I'm answering this question before my legal submissions are over, because most of your lordship's questions can only be answered from my legal submissions, which are yet to follow. But my immediate answer is this.
You see, looking at it in hindsight, they had lost the mathematical equation they had lost. It was very obvious that when 34, and that's why, as Mr. Jetlani said yesterday, they were not willing to disqualify all the 39, because they also realized the moment you disqualify 39, then it redounds to their disadvantage. So they were trying to disqualify the 16, so that you give a threat to the other 23 that look, you will also suffer the same fate. All right. They also knew that they were likely to lose the plot, but we are now on the governor's powers. We're not so much on the mathematics. And okay, now at the end of it, it's very obvious that they had lost the numbers game. But equally, what is a very serious concern is that governor should not enter into this any area by which their action will in fact precipitate the fall of a government.
That is where I would very earnestly and respectfully, my lord, differ constitutionally, and I'll answer that.
Stand away and say that, look.
Lord, can I, before your lordship, my lord, concludes on this point, Lord, would your lordship, my lord, allow me to narrate, my lord, place the law on the point? Because law, as I have understood, my lord, subject to your lordship's final approval, may not, my lord, support this conclusion. My lord, if there is a dissatisfaction, the governor's responsibility is to ensure that the stable government is there and government functions in a stable way. If somebody goes and says that there is a party dissatisfaction inter se, may not be a ground for the governor, my lord, possibly to call for a trust vote.
Suppose there is a political party.
My lord, if your lordship.
MLAs of a political party feel that our leader is not true to our ideology, that our leader is not carrying out the basic ideological premise of our party. Take it. Forget Uddhav Thackeray, forget Shiv Sena for a moment. They have their remedies. They can always say that we'll vote our leader out. We believe that our leader does not pursue the ethos of our party. They can always vote the leader out in a party forum. But can the governor say that because there is a dissension about a certain aspect of the leadership, therefore I'll ask them to now prove it's a government which has been formed. It is a government which has established its majority on the floor of the House. It's a government which is a functioning government. And and we are now not at the inception where you have to ask for a trust vote. I'm not saying that there is an absence of power in the governor. There is, of course, there's a power in the governor even after a government is formed, because a variety of things may happen which will lead the governor to say, no, prove your trust on the floor of the House. But what is really the problem here is that governors, in exercising that power, may actually precipitate the fall of the government. And that is something which is very, very serious for our democracy.
May I answer, my lord? Okay, I'm running against time, but your lordship would accommodate me, my lord, obviously. I'm on the first point right now. One.
And this is irrespective of their numbers. There's no doubt about it that they lost the numbers at that point of time. But
Lord, I am answering as a proposition of law. Lord, kindly allow me to at least answer, Lord, this. I have understood, Lord, your Lordship's concern on the constitutional proposition, which is canvassed, Lord, by a party which has otherwise, Lord, lost the majority support, as the figure suggests.
and all this hyperbole that you'll have 40 corpses and all, this is Maharashtra. It's not some. It's a very highly cultured, developed state. I mean, things are said in politics. Sometimes things are said which are inappropriate. They should never be said. As we said just the other day, Mr.
Please
Mehta,
don't, my lord,
that we said to Dr. Singhvi in a matter where he was appearing that there has to be some level of constitutional discourse and dialogue, which is unfortunately going down in our country. So we are not condoning it. We are not at all condoning
please
it.
don't, this amounts to condone.
No,
That's
no,
why
no,
my
no,
concern
no.
is.
No, we are not condoning it. In fact,
Lord,
we have expressed the
Can I
most serious concern about where it's like, in fact, in one of our orders, just Narasimha and I say it's like a race to the bottom. But that is different. I mean, we're not condoning it at all. We are deeply concerned with it as a constitutional court. But equally, we have to also say that what about the governors? They must exercise these powers with the greatest circumspection and
Would
caution.
your lordships consider deferring this view till, my lord, my...
All right. We'll see the judgments, of course.
Yes, Lord. Lord, kindly allow me to answer at the outset. I'll show the judgments. Lord, whenever the governor's prime responsibility is that a stable government continues, number one. Kindly allow me to complete. Number two, the democratically elected leader should not only enjoy the confidence of the House when the government is formed, he should continue to enjoy the confidence of the House throughout the tenure. And that's going to be my another limb of submission when I examine, my lord, the governor's power in facts of the case is concerned. Otherwise, there would not be any accountability on the leader so far as his constituent electorate is concerned. He can say that now I am elected to hell with you. I will not concern. I am not concerned.
See, the monsoon
Allow me to.
Mr. Solicitor, the monsoon session was coming. This was all happening in the third week of June, the last week of June.
Can I complete?
The monsoon session of the State Legislative Assembly was going to take place when you will place supplementary demands. That's the surest test. If they have to seek the vote of the House on passing legislation, on supplementary demands, one aspect of a revenue measure, and if the government does not get a vote, they're out.
Well, I will show the judgments. Well, the judgments
of the monsoon session which was going to take place.
Well, I'll have to, my lord, read some judgments also, my lord, and therefore I would earnestly request your lordships to defer this tentative conclusion.
This is not a conclusion at all. This is a concern which we are
Another thing.
We may eventually accept your submission and we will equally put your argument to Mr. Sipar.
No, I understand. I'm fully conscious. I'm confident and
quality. What is happening is
my worry is difficult. My worry is different.
Ultimately, whoever fails, whoever succeeds is a separate issue. But
Lord, my worry is different. My worry is different. And I'll put it first, Lord. Thereafter, I'll answer that question at the outset and elaborate. But what was said was not just an inappropriate statement which the governor could have ignored. It was a threat that you will be brought dead and sent to postmortem. That the House is being... Please don't condone it, not even inadvertent.
He wrote to Mr. Limay, who was the additional chief secretary, provide security. He did his duty by providing that please provide protection. Your duty bound.
Permit me, Malad, to... Anyway.
But bringing down a government because of some member of the Legislative Assembly saying that, we will,
Sorry, my lord, that's too simplistic a way to look at it. Lord, please look at it holistically. 34 MLAs goes that we have lost confidence. They might be disqualified, they may not be disqualified. Whatever is the consequence, forget it for the time being. Along with 2 + 7 other MLAs that this man is not enjoying majority support. Kindly, my lord, allow me to complete. My lord, before your lordship, my lord, expresses the concern. They are not saying that we don't like him or we don't like the A, B, C, D reasons, and therefore he has lost our confidence. Now, my lord, all these allegations, all these threats are being administered, and the governor is supposed to be not a mute spectator because the threats are administered not as a law and order situation. The threats are administered and governor is informed that with a view to create an artificial majority, now not only threats are administered on public platforms, but really attacks are taking place. My lord, would I expect the governor to sit as a mute spectator and say that you wait till your monsoon session? This is your internal dispute. You sort it out internally. The minimum thing, my lord, the Supreme Court has said is that the governor is not only entitled, he is duty bound to hold a, to direct that if this is the situation, you hold a floor test. If that, my lord, according to their perception, might aggravate the situation for the chief minister, my lord, again, that consequence is not for the governor to keep in mind. If in a democratically elected body like the member, like a legislative assembly, if I am elected as a leader, I should not only inspire confidence at the outset, I should continue to have that confidence throughout my tenure. Otherwise, it results into complete lack of accountability and answerability, which is a facet of democracy, and it would result complete in complete tyranny. That now I'm elected, you can do nothing to me. Look, that is not what is conceived of the governor's function, because governor comes into picture only in rare situations like this, that for whatever reasons you have lost your confidence. If 34 people have come, maybe because of my floor test, 34 may become 40. I'm taking the extreme example, as your lordships have very rightly expressed the concern, that it might aggravate the situation, but that's how the democracy works. That's how, my lord, leadership works. And therefore, my lord, they say that you can inherit leadership. You cannot inherit leadership qualities. And that is where the leadership quality comes into play in a democracy.
The concern, Mr. Mehta, is that what happens is people start ditching a government. And, you ditch your government, and then for a variety of reasons, the governments and the governors are willing allies by saying, hold a trust vote. So you give sanctity to this act of.
I am not entering into the area whether they should have or they should not have. That's for them to answer.
This is a very sad spectacle, in our democracy that, you allow.
My lord, I don't, as a governor, I can't answer that question. But otherwise, my lord, if your lordship.
I mean, this is irrespective of the morality of the Shiv Sena having joined with the INC and the.
That was also, my lord, the majority feels was a sad spectacle. My lord, ultimately, all these resolutions say that having gone before the electorate, and my lord, I would like to read, my lord, kindly allow me, my lord. Okay, my lord, I am, kindly allow me. In Quixote, your lordships very carefully say that when you go before the electorate, you are not going as an individual. You are going as a representative of a particular ideology. You are doing two things. I am representing a particular ideology, vote for me. He represents another ideology, don't vote for me. Now the situation before your lordships and before the governor was that majority of me who went with a particular ideology, particular coalition, particular, my lord, joint, my lord, program, sit with him against whom we contested the election, and majority say that this is a spectacle we would not like to be a part of. I'm not concerned as a governor. I'm not concerned as a governor. So that's, my lord.
And but they broke bread for 3 years, no?
Exactly.
They broke bread with the Indian National Congress and the NCP for 3 years. What happened overnight after 3 years of, a happy marriage?
My lord, please see, my lord, then I'll read, my lord, what is their reason, because it's not my function to answer that. That's a political debate.
The governor has to ask himself this question.
On lighter side, you can very well say, staying together for 3 years cannot be said to be a happy life by that.
But the governor has to ask himself this question. What were you fellows doing for 3 years?
Lord, governor has.
You're not in 1 month after the election has taken place.
Lord, kindly come to
1 month after the election takes place.
Lord,
the
I have not
suddenly breaks up with the bypasses the BJP and joins with the INC. And governor can say, sorry, there's a serious discontent in the party.
Lord,
3 years you cohabit, and then suddenly one fine day, a group of 34 say that there is discontent.
Kindly allow me to place.
They all went and became ministers.
Lord, the difficulty is, my lord, out of
enjoying the spoils of office, and then suddenly, one day you just
wake up to the fact that
I leave it to your lordship. Well, that's a political debate, but I have an answer. If your lordship allows me, I'll answer.
You can go to the law council.
Yeah, now tell us, show us the law now.
Huh?
I will.
You
But
take
before
us to
that,
the
let
law
me
first,
answer.
then
Let
thereafter
me answer.
apply the later.
Well, let-
Please do one thing. You can show the law, correct? Power of the governor, what can be waged with the government, and thereafter you take it to take us to the later, that whether it fits in that law or not.
My lord, kindly, my lord, note here at this page
Yeah.
14 is the answer. I'll come to it later.
All.
Page 14, why these 3 years of cohabitation, my lord, and why thereafter, my lord, a divorce. I'll answer, my lord. They have answered to me. They have shown it to me. Me means the governor. The governor is given why we have been together and now what are why it's now or never situation, my lord. That I'll kindly, my lord, allow me to place it at page 14, my lord. Now, your lordships, my lord, kindly take these propositions, my lord, and that would, my lord, perhaps answer your lordship's questions. Because otherwise, my lord, I may not be able to fulfill my promise of, my lord, concluding in.
No, you are right, absolutely. I took some time out on asking.
No.
You're right, absolutely. No.
As,
It's just that sometimes, you
just, my lord, on a lighter
just
side,
get. No,
when the
absolutely.
court is quiet, my lord, as I said, the arguments are longer. And, my lord, just since everything is, my lord, now very, very serious, and I want to start the new point not on that serious note,
let's see that.
kindly allow me to use, my lord, one, my lord, kindly, before your lordship takes the proposition. Before your lordship takes the proposition, my lord, on a little light note, I'll start. But there is a Urdu couplet, Mr. Sibal is fond of, my lord, both of us share that. There is a very good Urdu couplet on the situation which is arising. मैं चुप रहा तो और गलत फहमियां बढ़ी. This for the court. When the court is quiet, then we don't understand what is passing in the court's mind. मैं चुप रहा तो और गलत फहमियां बढ़ी. वो भी सुना है उसने जो मैंने कहा नहीं. So, this is.
सुना है उसने जो मैंने कहा नहीं.
वो भी सुना है उसने जो मैंने कहा नहीं. मैं चुप रहा था. So when your lordships are quiet, we understand that there are 10 points.
Mehta, पर वो भी सुना जो मैंने कहा नहीं. What we in legal parlance call reading between the lines.
But those who write shares, they don't write for legal documentation. They write for some particular person. They write for one individual. That one individual is relevant for them, those who write.
By the way, who is the author of the couplet, Iqbal, or who is it?
No, this is Wasim Barelvi.
Oh.
Very fine. One of the top ranking alive poet who is alive. Contemporary Urdu.
By the way, Mr. Sibal, I don't know if Mr. Tushar Mehta, whether you've read this book called Dilli or Dilli, which is written by one of our lawyers of the Supreme Court Bar. It's a beautiful book on,
beautiful, yes.
On a variety of Urdu poets.
Yes, Delhi had that tradition. Now it's dying. Unfortunately, the best tradition was in Lucknow. Lucknow also, I asked people that there's a dying tradition. In Allahabad also, Firaq Gorakhpuri and all, my lord, now that tradition is fading away. I'll not say dying, but it's fading away, my lord. It's not. But there are young, my lord, writers.
It's an issue of language, my lord. Actually, language is taken over. And Urdu is a dying language as of today. That's the reality. And therefore we are losing a lot of that culture. That's what it is.
Yes.
You'd like to go through your propositions?
Yes, my lord. Kindly, my lord, come.
Go through your propositions, so then we are done. We just
Lord,
then look at the
para 4,
judgments.
para 4, my lord. Para 4. Lord, page 1, para 1, my lord. In a parliamentary democracy, the cabinet and the chief minister must enjoy and must continue to enjoy the majority support of the house at any given point of time. It is the constitutional obligation of the governor to ensure that government is stable and the government as well as chief minister enjoys majority support in the house. The argument, my lord, third, right now your lordships may ignore, I'll come to it a little later. 4, the question as to whether the government or chief minister has lost confidence or support of the house is not to be decided by the governor and shall have to be decided on the floor of the house. the governor, based upon the material from wherever derived. Well, this expression I have borrowed from Bomai, from wherever derived, because this was an expression used by the committee of governors appointed in 70s, and Bomai has approved that report, my lord, can only arrive at a conclusion that prima facie the cabinet or the chief minister has lost confidence, support of the house, which requires to be tested on the floor of the house. His satisfaction is limited only to the requirement of floor test and not whether A enjoys majority or B enjoys majority. Now, my lord, your lordship's very pertinent question was that if, I'm sorry, my lord, your lordship, sorry, that merely because there is some internal dissatisfaction amongst the party, can the governor take this call or not? Lord, a similar question arose, my lord, in case of Rameshwar Prasad, where the question was that you're permitting somebody to request you to hold a floor test would violate 10th schedule. Because what these people, this group who is expressing no confidence against the chief minister, stand disqualified or will stand disqualified under the 10th schedule. And the question before the court was whether the governor, while taking a decision under say, Article 174 and 175, is concerned what will be the effect of their act ultimately in the 10th schedule. I hope I'm able to make myself clear. While taking the decision, I am supposed to be cognizant that what they are doing might be a reason for 10th schedule punishment, a consequence subsequently. Your lordships, my lord, through a constitution bench says no. My lord, please take, my lord, my lord, 2006, volume 2, SCC, page 1. I'll read only 4 paragraphs on this point. That governor is agnostic to 10th schedule. He has to be satisfied that the confidence is lost prima facie. It needs to be tested on the floor. They may suffer consequence, they may not suffer consequence. That's not the governor for the governor to see. That's what your lordships have said. Lord, kindly see PDF page 393 in JC volume 1.
There are two important things which the governor has not taken into account, which to my mind were extremely important. One, that insofar as the Congress and the NCP are concerned, there is absolutely no shaking up of there is no internal dissension in either the Congress or the NCP. Congress had 44 members, NCP had 53 members. This is a block of 97. There's absolutely no dissension in either Congress or the NCP. So in the 97 still continues to be a solid block. What is disturbed is, say, out of the 56 that the Shiv Sena had, 34 have expressed a...
Which brings it down, to, your lordships are...
So out of the second thing which the governor had to bear in mind is this, that as of this date, there is not even a suggestion that the Shiv Sena is going to team up with the BJP to form the government. So that's again a circumstance which is totally alien to his consideration. So he can't be oblivious of the fact that in a three-party coalition, the dissension has taken in one party out of the three. The other two are steadfastly support the coalition, and they are not by any means, sidekicks. They are almost at par. All the three are virtually at par, except the Congress, which was a little lower.
May I only make one
lower
request?
than the.
May I only make one request? Look, to examine the facts of the case, after, my lord, I show the law, your lordships are shown, but some of the paragraphs, some of the law is unfortunately, my lord, not assisted.
2006.
Thereafter also, my lord, why the governor can take that step, even if NCP Congress block is not disturbed? I'll, my lord, answer that. Lord, it is para.
What is the citation, Mr.
Lord, 2006, volume 2, SCC, page 1. Para 85.
Which compilation is it?
But judgment compilation 1. Lord, PDF page 482.
Starts from page 393.
Yes, yes.
Want to go to 482.
482, Lord. Para 85. I'm reading 85, 161, 164 and 165, which is on this point, my lord. And my lord, kindly bear one factor in mind. My lord, whether the court would have taken the same view which the governor took may not be the test while determining, my lord, the decision taken by the governor. Court may perhaps on the facts arrive at a different conclusion. Lord, 85. Certainly there can be no quarrel with the principle laid down in Quixote case about the evil effects of defections, but the same have no relevance for determination of the point in issue. The stage of preventing members to vote against the declared policies of the political party to which they belong had not reached. If MLAs vote in a manner so as to run the risk of getting disqualified, it is for them to face the legal consequences. That stage had not reached. In fact, the reports of the governor intended to forestall any voting and staking the claim to form the government. Well, this was a case of 356. He sent a report that now dissolve the government. Yes.
The stark distinction, so far as Rameshwar is concerned, Rameshwar government was not formed. It was at the initial stage immediately after elections,
Correct.
where there was no party who got the majority. Instead of waiting for somebody to form a majority, the governor asked for dissolution of the House.
356. Already exercised.
And the reason he has given is that if I spend more time to allow a coalition to be formed, they will cobble up a majority and thereby violate 10th schedule and then create a government. So court said the governor cannot assume that one of the political parties would go ahead, cobble up majority by coalition. This is a wrong inference that the governor has drawn. But as against Rameshwar Prasad's case, this is a case where the government is subsisting for more than 3.5 years. So that's the distinction between Rameshwar and ours. I'm just putting it to you.
Facts, yes, but the legal proposition which I would, my lord, place for your lordship's consideration may be the same. The consequence which would, the power of the governor or the exercise of power of the governor at the time of initial formation or subsequent shall have to be the same. That's my respectful submission. Please come to, my lord, now PDF page 520 at para 161. Because I, my lord, with profound respect, do not see any any reason to not read this ratio for exercise of power under 174 and 175 also. This was also the case where the Supreme Court said you should have called for the floor test. You could not have said that, no, they might incur disqualification. 161, my lord, if your lordships, my lord, can. We are not, your lordships gets that, my lord. We are not impressed with the argument based on a possible disqualification under the 10th schedule if the MLAs belonging to LJP party had supported the claim of so-and-so to form the government. At the stage, it was wholly extraneous to take into consideration that some of the members would incur disqualification if they supported a particular party against the professed stand of the political party to which they belong. The intricate question as to whether the case would fall within the permissible category of a merger or not could not have been taken into consideration, assuming that it did not fall in the permissible arena of merger and the MLAs would earn the risk of disqualification. It is for the MLAs or the appropriate functionary to decide and not the governor to assume disqualification and thereby prevent staking of the claim by recommending dissolution. My lord, your lordships are right. My lord Justice Narasimha are right. Fact situation was 356. But why, my lord, I'm posing a question to myself. This ratio not apply when the governor decides to call for a floor test, which your lordship said is the only test. My lord, further, it is not necessary for us to examine for the present purpose para 4 of the 10th schedule dealing with merger and or deemed merger. In this view of the question sought to be raised, my lord, kindly see the last line. It could not have been gone into by the governor for recommending dissolution. My lord, what fell from my lord the Chief Justice would be, my lord, if I put it in the context of this ratio, would be that the governor will have to first form an opinion that these people are working since 3 years. They have a reason to, they have shown the reason to the governor why they are parting ways after 3 years. But can they do it after 3 years? Would it not amount to a split? Would it not amount to disqualification under Chapter 10, Schedule 10? My lord, kindly come to, my lord, 160, 162, my lord. The provision of the 10th schedule dealing with defections, those of the RP Act dealing with corrupt practice, electoral offences and disqualification, etc., and are legal safeguards available for ensuring purity of public life in democracy. But insofar as the present case is concerned, this had no relevance at the stage when the dissolution of the assembly was recommended without existence of any material whatsoever. There was no material for the assumption that claim may be staked based on democratic principles, but based on manipulation by breaking political parties. Now kindly come to, my lord, 164 and 165. It is true. Does your lordship have that? It is true that, and kindly, my lord, for my satisfaction, read it as 174, 175 instead of 356. It is true, as has been repeatedly opined in various reports and by various constitutional experts, that defections have been a bane of Indian democracy. But at the same time, it is to be remembered that defections have to be dealt with in the manner permissible in law. If the political party, with the support of other political party or other MLAs, stakes claim to form a government and satisfies the governor about its majority to form a stable government, the governor cannot refuse formation of the government and override the majority claim because of his subjective assessment that the majority was cobbled by illegal and unethical means. No such power has been vested with the governor. Such a power would be against the democratic principles of majority rule. The governor is not an autocratic political ombudsman. If such a power is vested in the governor and or the president, the consequences can be horrendous. The ground of maladministration by a state government enjoying majority is not available for invoking power under Article 356. The remedy for corruption or similar ills and evils lies elsewhere and not in Article 356(1). In the same vein, it has to be held that the power under the 10th schedule for defection lies with the Speaker of the House and not with the governor. The power exercised by the Speaker under the 10th schedule is of judicial nature, dealing with the question whether power of disqualification of members of the House vests exclusively within the House to the exclusion of the judiciary, which is in Britain was based on certain practices of the British legislature as far as India is concerned. My lord, it has been said, I'll skip that. My lord, please see 166. The governor cannot assume to himself the aforesaid judicial power and based on that assumption come to the conclusion that there would be violation of the 10th schedule and use it as a reason for recommending dissolution. Lord, he also cannot refuse floor test.
But look at what the consequence of these observations in the present cases. The governor,
I earnestly request your lord.
But we are, since beyond those two paras, just those two paras. No such, the court says, the governor cannot refuse the formation of the government and override the majority because of his subjective assessment that the majority was cobbled by illegal and unethical means. Therefore, irrespective of what the governor feels or what somebody else feels about, the fact that in forming a government with the INC and the NCP, you gave up a pre-poll alliance, it is irrelevant to the governor. This is a government which has been legitimately formed. All right, that's step one. Second, para 166 says that the governor cannot assume to himself the aforesaid judicial power and based on that assumption come to the conclusion that there be a violation of the 10th schedule. So it was alien to the governor's mind that these 34 would have to be excluded from consideration because they have incurred a disqualification under the 10th schedule. For the governor, he has to treat these as part of the Shiv Sena, irrespective of what their internal differentiation is. Therefore, he cannot now say that this 34, the letter which these 34 have given me, is a ground for shaking the faith of the government or the trust of the government which they have. He has to take these 34 as forming a part of the Shiv Sena legislature party.
Now let me show.
And if they are a part of the Shiv Sena legislature party, where is there any ground to say that, well, there is now a change in the position of trust in the House? Prima facie, at least, for him.
Now, Lord, let me show the judgment of the High Court, which was dealt with by Bomai judgment. Your Lordship's, my Lord, very right concern, my Lord, comes in the form of Mr. Sorabji's arguments, which was rejected, and your Lordship in Bomai did not accept that rejection. Kindly, my Lord, allow me to place, my Lord, that High Court judgment, my Lord. Because when we cite Bomai, my Lord, we generally don't see the High Court judgment, my Lord. Kindly see, my Lord, para 32. And this would be, my Lord, an answer. And, my Lord, please, again, my Lord, I am requesting, please examine the law as agnostic of the facts right now. And thereafter, my Lord, I will assist your Lordship on the facts. What is the law? What is the power of the governor? What are the contours of power? What are the limitations? Lord, please come to para 32 at 2472, my Lord. The right-hand side top is the pagination.
1 minute.
2472, my Lord, para 32. So this can be, my Lord, my answer.
There are 32.
32, my Lord, at page 2472 of this judgment. Lord, left or right hand side top, my Lord, is pagination. May I read, my Lord? Your Lordships have got. Mr. Soli Sorabji also contended, this is his argument before the High Court, my Lord, that the factors like alleged unethical methods adopted during the formation of Janata Dal, expansion of cabinet, horse trading, and atmosphere getting vitiated are not only vague but have no rational nexus at all. The question of failure of constitutional machinery, the learned counsel also laid, my Lord, kindly come down, my Lord. Anti-defection law, my Lord, it says, I'll just read fully. The learned counsel also laid great stress by contending that governor, by acting upon the letters given by 19 legislators, had circumvented the anti-defection legislation, the primary aim of which is to discourage the toppling game by legislators by changing their loyalties, and by acting upon those letters, the legislators were permitted, in substance, to play the game of toppling the ruling party, ruling ministry, without incurring the consequence of anti-defection law, because if these legislators had withdrawn their support in the House and voted against the ministry, they would have incurred disqualification under anti-defection law. Reliance upon these letters is contrary to the underlying purpose and the essence of anti-defection legislation, and therefore illegitimate and prohibited. Kindly mark this. The learned counsel buttressed these arguments by contending that if the floor test had been held, the legislators would have written letters, who had written letters might have changed their mind for several valid reasons, i.e., change of the style of functioning of leadership, change in the leadership, realization for maintaining party unity, unwillingness to incur disqualification under anti-defection legislation, and 5, not giving a pretext for imposition of precedence rule. In support of the contention that the floor test has always been recognized as the legitimate and relevant method, Sri Sorabji relied on the judgment of Orissa High Court, so and so, so and so. Lord, he was insisting that please allow floor test, because that's what the law says is the only test. That's what we call dance of democracy, is on the floor of the house, not outside. And the governor cannot go beyond a particular point. Lord, this was rejected by the High Court, my Lord, at para 54. 34. Page 2475. May I read, my lords? Mr. Soli Sorabji had made pointed reference to the 10th schedule, that is anti-defection law, for bringing home this point, that the factum of the withdrawal of support by 19 legislators was wholly irrelevant. This argument was advanced to prove his point that in
34.
I'm sorry, my lord, page 2475, para 34. I'll read again, my lord, for my Lord Justice assistance. Mr. Sorabji had made pointed reference, this is the finding of the High Court, pointed reference to the 10th schedule, i.e. anti-defection law, for the bringing home his point that factum of withdrawal of the support by 19 legislators was wholly irrelevant. This argument was advanced to prove his point that in the context of anti-defection legislation, floor test was the most relevant, legitimate and surest method to determine whether the Council of Ministers headed by Sri Bomai commanded the majority in the House or not. We are afraid we are unable to agree with this submission of the Learned Council. The introduction of 10th schedule in the Constitution has not in any way affected the exercise of powers under Article 356, nor has it amended Article 356 in any manner. The amending body which inserted the 10th schedule to the Constitution had before it the several decisions, especially the Rajasthan case as to the scope of Article 356. There is a presumption that the lawmaking body was aware of the existing interpretation, and the court said that no, he should have kept Schedule 10 in mind while exercising powers under 356. Now, my lord, please see how Bomai judgment deals with this. Lord, it was pointed out that para 397, my lord, was read out of context, my lord, to show. Lord, kindly see, Lord, Bomai is, my lord, JC volume 2, PDF page 516. Yes, my lord. Your lordships, my lord, in the judgment of Justice Jivan Reddy, my lord, at page 516, my lord, para 389 formulates the question. Volume 2. I'm sorry, my lord, my allotted time is over, my lord, kindly allow me, my lord. I am not repeating anything, my lord, and
Certainly.
the 389, my lord, your lordship says, I'm not reading all questions because they are not relevant for the present. Only question number 6. A special bench of 3 judges of High Court heard the writ petition and dismissed the same on the following reasoning. Please come to 6, my lord. The introduction of 10th schedule of the Constitution has not affected in any manner the content of power under Article 356. Lord, the argument of Mr. Sorabji was that all right, why you are not concerned with 10th schedule. Direct floor test to be held. Don't dismiss the government under 356 straightway. And, my lord, the court, my lord, thereafter records, my lord, page, my lord, 393, my lord. I'm sorry, my lord, 397. In this context, my lord, the court examined this, my lord, that it is wrong. The governor should consider before removing the ministry, before not installing the government and imposing precedence rule, you should have given the floor test. And that in that context, my lord, 397. Please see, my lord, 397. May I read? We are equally of the opinion that High Court was in error in holding that enactment or addition of 10th schedule to the Constitution has not made difference. The object of 10th schedule is to prevent and discourage floor crossing and defections, which at one time assumed alarming proportions. Whatever may be his personal predilections, a legislator elected on the ticket of a party is bound to support that party in case of division or vote of confidence in the House, unless he is prepared to forego his membership of the House. The 10th schedule was designed precisely to counteract horse trading. Except in case of split, a legislator had to support his party willy-nilly. This is the difference between the position obtaining prior to and after 10th schedule. Prior to the said amendment, the legislator could shift the loyalty from one party to the other any number of times without imperiling his membership of the House. It was as if he had property in the office. That, my lord, in that context, the request was that give me floor test. Don't impose precedence rule. Let the 10th schedule play its role. If somebody votes against the will of the party, he will be disqualified. But don't take extreme step of 156. take step under 174 and 175. That's what precisely the governor has done. And, my lord, a similar situation arose. And, my lord, now I will read your lordship's the judgment in Shivraj Singh Chauhan, where all this is considered. But before that, please come to para 7 of my propositions, my lord. There are more than one reasons, my lord. Why, my lord, this cannot be the argument of the petitioner, and I'll demonstrate, my lord, what is the flip side of this argument. If your lordships, my lord, were to hold that governor cannot examine the inter se dispute, or he waits till the speaker decides disqualification, what is the flip side? I must, my lord, assist your lordship with that flip side. Para 7. There is one more reason why governor cannot preempt the decision of the speaker at the stage of directing floor test, since it is possible that the original political party of the members of the house may condone the defiance of the whip as contemplated under para 2(1)(b) of the 10th schedule. Lord, kindly pause here for a minute. Lord, disqualification is not automatic. If I, as a member of legislative assembly of a particular party, vote in defiance of the whip, there is a provision that the party may condone it within 15 days. So governor cannot say that I'll wait for 15 days when he is presented with the facts that this is the dissatisfaction the government has, because party may.
Mr. Solicitor, there are two
Lordships are examining proposition.
Right, there are two different distinct things. One is a dissatisfaction within a party, right? And the other is the loss of majority of the government. One is not necessarily indicative of the other.
Correct.
Now tell us, in this situation which we had over here, we now put ourselves in the shoes of the governor. What was it that would have led the governor to come to the conclusion that the government had lost the majority? What was the factual basis for him to conclude?
Again, only one thing, kindly bear one.
Only one 34.
Who were part of the government, who were supposed to be having confidence of the chief minister.
Right. So what
Second,
therefore now let's go to the bottom of it.
Look, can I first take the lordships to the bottom?
What is the governor saying? These 34 who are part of the Shiv Sena have now expressed their dissatisfaction with the leadership of the Shiv Sena. Unless the governor says that the natural corollary is that these 34 will cease to support the Shiv Sena.
I'm sorry.
Sorry. Not even that. We will make every assumption in favor of the governor's decision. Because that's how we test the proposition. What could the governor have said, though he doesn't say that these 34 persons who are part of the alliance between the Sena, the Congress and the NCP have now expressed their dissatisfaction. He can call for a floor test if he has any circumstances before him to indicate that the strength of this three-party coalition has been substantially reduced. Boma is absolutely correct, it binds us anyway, that this disqualification issue under the 10th schedule is completely irrelevant. But what is the consequence? The governor has to treat these as continuing members of the Shiv Sena. Even before us, they are not saying that we have ceased to be members of Shiv Sena.
Yes.
Now, if they continue to be members of the Shiv Sena, and the Shiv Sena therefore continues to have 55 or 56 members, which it originally had.
If they vote against, they will incur disqualification. Governor would say that.
Right. But then where is the question? What is the reason for calling a trust vote?
Because they said that
governor, all our judgments say, Rameshwar Prasad says that, Bomai says that the 10th schedule disqualification is irrelevant to the exercise of judgment by the governor.
I am obliged.
That authority goes to the speaker. Therefore, the facts as they stand before the governor indicate that these 34 are part of the group of 56 Shiv Sena MLAs. Now, if that is so, on what cogent material does the governor call for a floor test? What has changed for him to call for a floor test?
The difficulty is
Tell us one reason why he has to call for a floor test then.
My lord, your lordships are again on facts, my lord. I am on propositions first. And then, my lord, I'll try and fit into the propositions to the facts of the case. Number one. Number two, principally.
Forget the facts. Forget the facts.
Principally.
Forget the facts.
What?
The governor, as a matter of principle now, Bomai tells us and Rameshwar Prasad tells us that circumstances which would lead to the which would warrant the invocation of the 10th schedule are alien to the mind of the governor when he calls for a floor test.
Correct.
All right. So therefore, the possibility that these 34 in our case would incur a disqualification is irrelevant to the exercise of power by the
I
governor.
bow down, my lords.
Right? Now, if that is so, then the governor must forget the facts of this case, the prime principle. The governor must proceed on the basis of the position as it obtains. When the government has been formed, there is nothing which has, unless there is something, some subsequent event which alters the legal constitution of the government, the governor must continue to have before him and analyze the situation on the basis of the situation as it was when the government was formed and prior to the 21st of June in our case. He can't go into the 10th schedule, that's the speaker's jurisdiction. If he can't go into the speaker's jurisdiction, which is the 10th schedule, then what is the basis for calling a floor test? The only reason why he could have called for a floor test is that these 34 numbers, these 34 have alienated themselves. They have given up. They say that we have lost faith in Uddhav Thackeray, and therefore these 34 are excluded, the numbers.
But there also, Mr. Solicitor, there's one difficulty for them, and we are only looking at the material that is available for the governor to draw an inference that floor test is necessary. We are not about the facts of the case. Three factors you have indicated. One is the 21st of June letter. Second is the case of threats. Third is about BJP's, and fourth is about the independence letters. Those two, if we eschew from consideration, because from the opposition side, for him to base his decision, apart from threats, which is purely a law and order situation, what is remaining is the 25th.
It's not a law. I'm sorry.
21st of June 2022 letter. That letter merely informs the governor that we reaffirm that Shinde to be appointed and continues to be appointed as the leader of the house. Number one. Number two, Gogawale will be the whip. You continue to recognize that. Nothing more than that. It doesn't say anything more than that letter.
Allow me to, my lord, answer.
So now where does he draw an inference on the basis of this letter, which will become part of the material for him to take consideration?
Lord, please come to, my lord, page 14 of the material, my lord, which I have placed on record, my lord. It's not just a letter, it is coupled with
Yeah, we've seen that.
a resolution. Coupled with a resolution. And, my lord, kindly bear
Resolution of the 34, right?
34, my lord. It's not read before your lordship. Lord,
Just 1 second, let's go to that.
it's a PDF page 14, my lord.
That is at
401.
14.
list of LOD of the governor, no? That's what.
LOD of the governor. Yes.
No, that is that's what I was referring to, correct?
That's not what page?
14.
Page
14.
14.
Yes, 14. That letter, that resolution.
Right.
We, your lordship, sir.
Just see 17.
Yeah. 17.
The following members of the 14th Maharashtra Legislative Assembly belonging to Shiv Sena, we are notified as the members of Maharashtra Legislative Assembly as members of so-and-so. We had unanimously elected Mr. Shinde on so-and-so as group leader. There was pre-poll alliance between Bharatiya Janata Party and Shiv Sena Party. There has been great dissatisfaction prevalent amongst the members of our party, that is Shiv Sena and our party cadre at large, on account of corruption in the government. Why this 3 years cohabitation and then, my lord, an attempt for divorce, using, my lord, that expression. Administration regarding police posting, corruption by the then Home Minister Shri so-and-so and sitting Minister Shri so-and-so, who is also in jail for involvement with underworld Don Dawood. Apart from above reasons, our party cadre faced tremendous harassment and distress on political as well as personal grounds from the opposition ideological parties who are not now a part of the government and were using their office and power to undermine the base and foundation of our Shiv Sena cadre. This is their reason. I am not justifying, nor can I put myself into the shoes of the governor. And with profound respect, your lordships would also examine not what your lordships would have decided with these facts, but whether there exists.
But what the governor can constitutionally decide. We are not going to go into what our view is the situation is.
Can you allow me to complete the sentence?
Duty and power of the governor. In the
Can I only complete the sentence?
And see page 17 now, PDF page 17. Hence, it is unanimously, the end of it, what do they say?
I'm on 15. Can you allow me to read 15 also? This is enormous discontent. There is enormous discontent amongst the cadre of our party, that is Shiv Sena, for forming the government with NCP and Indian National Congress, who are ideologically opposed to our party, that is Shiv Sena. Initially, they say that they are destroying our cadre base. They are corrupt, found to be corrupt in near past. We are facing embarrassment. Then they say there had been a compromise on the principles of our party, Shiv Sena, which had been a party with fierce ideological base and was formed for fighting of the rights of local Marathi people. For last 2.5 years, our party and its leadership has compromised party principles by aligning with the contrasting ideologies for the sake of achieving power in the state of Maharashtra. The ideology of our party's leader, late Shri Balasaheb Thackeray, was to give clean and honest government to the people of Maharashtra, and also without compromising on the principle of so-and-so, which was defeated at the first day itself by aligning with the opposition ideologies. Shiv Sena and Bharatiya Janata Party had forged a pre-poll alliance for 2019 Maharashtra Assembly elections. They sought the blessings of voters for this Shiv Sena BJP alliance, which the voters accepted and voted in favor of this alliance. After the results were out, the Sena severed its ties with BJP and formed an alliance with opposing parties which they fought against in the 2019 Assembly elections. This act of our party leaders had a tremendous negative impact upon the voters and the party cadre at large. As an elected member, I am answerable first to my voters, then to anybody else, my lord. Because 39 members can say that we will vote against the party even at the cost of being disqualified and ceasing to be MLAs. Then the governor is faced with a situation where there would be instable government which cannot withstand on its stage.
Which means he's going to the disqualification issue.
No, I'm sorry.
That's the problem.
That 39.
Right. All that you are reading up to PDF page 17, where they passed the resolution. The resolution is at page 17. There are two parts of this letter, two parts of the resolution. First part is, let's formulate it. One, the first part is BJP and Sena had a pre-poll alliance. One. In breach of the pre-poll alliance, the Shiv Sena teamed up with the Indian National Congress and the NCP. 2. 3. By teaming up with the NCP and the Indian National Congress, the Shiv Sena has militated against the core ideology of the Shiv Sena. 4. That there has been corruption in the government. And 5. That there is discontent within the cadre of the party. This by itself will not justify the governor in calling a trust vote. Never. That's what our judgments have repeatedly said.
No, your lordships have said otherwise in Shivraj Singh Chauhan.
The fact that the conduct of a government has gone against the core ideology of that party can never call for a trust vote. Now, what then is in that letter? What then comes in the resolution? Two things. That we reaffirm that Eknath Sambhajirao Shinde, who was elected as the leader of the party, continues to be the leader. And 2, that we reaffirm that Gogole is elected as the chief whip. 2 things. The first part of the resolution has no bearing on a trust vote at all. The first part of it only reflects on the fact that there's grave disquiet among these people that, well, you militated against our pre-poll alliance and the core ideology of the Shiv Sena. That's alien to the governor because they've formed government already. Second, what do? They merely reiterate that Eknath Shinde continues to be the leader of the party in the legislative party. How is this a justification for a trust vote?
I'll just
Change in the chief
answer
whip.
that question. Well, kindly come to page 21. PDF page 21. This is signed by 41 MLAs. Well, the difficulty is, my lord, we are trying to examine and analyze the justification given by 34 or 39, whether it could have been a justification for floor test. For governor, he has to only examine that, but for this 39, the government would fall. I would rather go for the floor test.
In which case, he is now saying, assuming. No, but you're right. You're absolutely right. You're spot on. There's no difficulty about it at all. Therefore, what the governor is saying is, but for these 39, as you rightly say, the government will fall. Can he look into the fact that but for these 39, the government will fall when exclusion of these 39 is postulated on the speaker passing an order for their disqualification under the 10th schedule. Until that order is passed, he cannot presume that they are going to be.
He is not.
It's a preemptory move.
Lord, I think we are.
To say that we remain part of that.
Correct.
government.
Exactly.
We are not parting company.
My lords are saying the same. My lords.
They say that we continue to be in the Shiv Sena.
Correct, my lord. But still, we don't
They
support the
continue to
government.
be in the Shiv Sena. Then how do you call for a trust vote?
Or what is the apprehension
Lord,
that the government
trust
has?
vote is not against Shiv Sena. Trust vote is against the government, against the chief minister. Correct. Lord, suppose what happens if the leader loses the confidence while members remain. Correct. Lord, now kindly see, my lord, kindly see the flip side of this. Flip side is this. Lord, today there is a government of Shiv Sena and BJP. Now, your lordship's, my lord, prima facie view is that merely because some people go and say that we don't trust this government, governor should not do anything, not that cannot do anything. Your lordship's prima facie view is, this is debate, my lord. I hope this is not the conclusion. Your lordships are only
in a dialogue.
Yes, it's a dialogue. Now, suppose today BJP has what, 106 members. Lord, 100 members were to say that we have lost faith in the leader. Even our chief minister, kindly allow.
Right.
Kindly allow me to.
So 106 say we have lost faith in Fadnavis. Okay.
Kindly.
He was a
allow
leader.
me to.
For a moment, postulate it. Yes, you're right. Absolutely. Exactly. You're absolutely on spot on.
Kindly see, my lord. Would your lordships consider giving governor the power to wait for the floor test and ensure that there is some management where the majority is created? That's the flip side of it.
Mr. Solicitor, you can never allow the governor to ask for a trust vote when there is absolutely nothing to shake the majority on the floor of the House. What is the trust vote for? Do you have the numbers in the House? The trust vote is not for determining who is going to be your leader in the House. No. The trust vote, what is the purpose of the trust vote? In a House of 288, do you have 144? That's the purpose. And if there is nothing to indicate that 144 is disturbed, who will lead those 144 is alien to the governor. It may not have been Uddhav Thackeray. They could have elected somebody else. The INC, NCP, and the Sena would have said, "Oh, we're electing somebody else."
Would your lordships come to page 21? There is a direction.
But that is a matter of internal party discipline. You see, that can never be a matter for the governor. Governor's trust vote is where the majority in the House is shaken. And where was there anything to indicate that this...
Page 21. Page 21.
Yes.
Yes.
Page 21.
Page 21.
Yeah.
This is 47 MLAs writing to the governor on 25th of June, para 2.
25th of?
As is common knowledge, we no longer wanted to be a part of the corrupt MVA government. However, we were being continuously threatened to continue supporting the incumbent government without our free will. Thus, left with no option, we were constrained to flee away, so and so. However, as yet another attempt to break out our resolve and arm twist us to give in to the demands of MVA government comprising NCP and INC goons, security which was earlier provided, etc. They say, we don't wish to support this government, meaning...
No, Mr. Mehta, if you will look at para 11, that's the conclusion. We demand security. That's all. They don't say we are parting company. Where do they say that? They say, please give us adequate security as also our family because it's
My
been
lord, the
withdrawn.
governor is not, my lord, a court where this prayer was not couched in this manner. He has to, based upon the material before him,
No,
arrive.
Mr. Mehta, what is being pointed out? What is being pointed out is this communication cannot be said to be withdrawing the support to Mr. Uddhav Thackeray.
My lord,
This is that what happened earlier,
what it says,
that
what it says, well, it may say that give us protection, but they say we no longer want to be a part of this corrupt government. Meaning
but
thereby
then-
47
then-
people are minus now
and they
from the
don't say
magical mark.
what is being pointed out, then thereafter they don't say further that henceforth, correct, we are not supporting this.
If it
we are
is a
withdrawing
petition, there is no
and
prayer.
therefore the subjective satisfaction.
What's the next step they took after they said we are no longer
Right.
want to be part of
continue
the
it,
corrupt
All
government?
right, you can just reflect on it. Yes, Mr. Mehta. Yes, Mr.
21 of the compilation of the governor, my lords.
Right.
Lord, please, Lord, note one difference. It's not legislative party members showing lack of confidence in their party. It's not their internal party affairs anymore. These members are saying that we are withdrawing support from the government. My lord, that's the distinction. And my lord, I would hasten to add, my lord, that this not being, my lord, a petition or a suit may not have a prayer clause, etc. But governor, my lord, as I will show from one para of Bomai, from whatever material, if he comes to the prima facie satisfaction, and that test is accepted by my lords, my lord, in the Shivraj Singh Chauhan judgment, that there is loss of confidence by this government, then he can ask, not only can ask, he should ask the floor test. My lord, kindly see para 2, my lord, once again. As is common knowledge, we no longer wanted to be a part of corrupt MVA government. However, we are being continuously threatened to continue supporting the incumbent government without our free will, thus left with no option, etc., my lord. And this is signed by 47 members of the Legislative Assembly, not just Shiv Sena MLAs, but independents and 2 members of Prahar Jan Shakti Party saying we are withdrawing support from the government. And oh my, this is, my lord, in my respectful submission, the material as
Para 2 mein first sentence.
my apologies. Lord, page 21 of my apologies.
Only it is a common knowledge that we no longer
Lord, govern
wanted since past
Wanted to be.
to be part.
No, it's past and continuous also. That we have already declared that we don't want to support, but now we are being pressurized to support. That's what. Lord, kindly see, and I'll show Lord para 393 Bomai. Lord, from whatever material he comes to a prima facie conclusion that there needs to be a floor test, Lord, he would be under an obligation. We don't want to support this government and therefore give us security because we are being threatened. Second, Lord, what is the fact situation before the governor? And I'll read only one para from Bomai. One set of MLAs, namely 47, saying that we want to withdraw support from the government. One set of MLAs, my lord, or the leaders of the party saying that we will see when you come on the floor of the house. In my respectful submission, I'm posing a question to myself: would the governor not be justified in forming an opinion that the government has lost confidence? I'm not saying anything. I'm not preempting anything. As Mr. Sorabji, my lord, narrated several possibilities, I'm only asking for the floor test. Maybe they might change their view. Maybe they might sacrifice themselves. Maybe they stand disqualified. Maybe they are persuaded. Maybe the leadership changes. There are several possibilities. The governor, my lord, in my respectful submission, my lord, will have no jurisdiction once he has a material. And what can be the material? Apropos her ladyship's question, my lord, page 393, para 393 of SR Bomai, my lords. It need not be a letter also. Well, suppose in a given set of circumstances, it's in public media, everywhere, which cannot be disputed. All channels are showing something. Lord, I'm posing a question to myself, my Lord, can the governor not examine those facts also? But ultimately, he is not just, my Lord, when a 174, 175 situation arise, he is not supposed to be a mute spectator. He will have to act. His action would be subject to judicial review within, my Lord, the parameters which your lordships have fixed, my Lord, for my lord's, my Lord, future assistance. But please see, my Lord, 393, which is at, my Lord, volume judgment compilation, volume 2, PDF 518. Lord, that's Bomai judgment, my Lord. Am I with your lordships, my Lord? My Lord Justice.
And Lok Prahari and these 17 independent MLAs were backing the government up to then.
Yes. Seven, my Lord.
Seven.
Not seven. And, my Lord, one set of 393. In this connection, it would be appropriate to notice the unanimous report of the Committee of Governors appointed by the President of India. The 5 governors unanimously recommended that the test of confidence in the ministry should normally be left to a vote in the assembly, where the governor is satisfied by whatever process or means. Please kindly see, my Lord. It need not be a prayer that please hold a floor test, etc., my Lord. People are telling him that the government is not enjoying our support. They've lost the confidence. By whatever process or means that the ministry no longer enjoys majority support, he should ask the chief minister to face the assembly and prove his majority within the shortest possible time. If the chief minister shirks this primary responsibility and fails to comply, the governor would be in duty bound to initiate steps to form an alternative ministry. A chief minister's refusal to test his strength on the floor of the assembly can well be interpreted as prima facie proof of he is no longer enjoying the confidence of the legislature. I'm sorry, your lordships. Lord, the subsequent event of the Honorable Chief Minister not deciding not to face, my Lord, justifies the decision that whatever material I gathered and the satisfaction I arrived at was a right satisfaction, that the government has lost the majority confidence. Now, my lords, may allow me to place, my Lord, the Shivraj Singh Chauhan judgment, my Lord. My Lord, and that, my Lord, I would earnestly request your lordships, my Lord, to permit me to read, because that was read by the petitioner, bits and pieces on, my Lord, this side, but not from the governor's point of view, my Lord. I'm sorry, my Lord, page 395, my learned friend is right. My Lord, para 395 also in Bomai, my Lord. 395. Because it's not a luxury which is, my Lord, conferred upon the governor. My Lord, it's a duty.
392 or
395, my Lords, of SR Bomai.
And what is the PDF
Same
page? Can you give me?
518, my Lord, judgment compilation 1. 2, I'm sorry.
5-1.
513. If only one keeps in mind the democratic principles underlying the Constitution and the fact that it is the legislative assembly that represents the will of the people and not the governor, the position would be clear beyond any doubt. In this case, it may be remembered that the Council of Ministers not only decided on so-and-so to convene the assembly on so-and-so, but also offered to prepone the assembly if the governor so desired. It pains us to note, Lord, your Lordship, that's on the facts of the case, my Lord. The governor did not choose to act upon the said offer, and my Lord, that was frowned upon by the court. Indeed, it was his duty to summon the assembly and call upon the chief minister to establish that he enjoyed the confidence of the House. Not only did he not do it, but when the Council of Ministers offered to do the same, he demurred and chose instead to submit the report to the President. Lord, here I am being asked by the person who did not choose to face the vote of no confidence, that why did you call for the vote of confidence? Why did you call for the floor test? The converse situation and more drastic, my lord, in terms of the facts. In the circumstances, it cannot be said that the governor's report contained or was based upon relevant material. There could be no question of the governor making an assessment of his own. The loss of confidence of the House was an objective fact which could have been demonstrated one way or the other on the floor of the House. In our opinion, wherever a doubt arises whether the Council of Ministers has lost the confidence of the House, the only way of testing it is on the floor of the House, except in an extraordinary situation where, because of all pervasive violence, the governor comes to the conclusion and records the same in his report that for the reasons mentioned by him, a free vote is not possible in the House. So, my lord, it's not his right, it's his obligation. Now, my lord, kindly come to, my lord, and, my lord, the threshold in my respectful submission is that some material which creates a doubt in his mind. And, my lord, I would, my lord, at the cost of repetition and with profound respect, my lord, please, this is a constitutional submission. Don't, my lord, misunderstand the submission. My lord, the threshold of your lordship's judicial review, which I am not disputing, would be whether there was any material, whether based upon that material, your lordships may perhaps would have taken a different view, may not be a test. Now, your lordships, my lord, kindly come to Shivraj Singh Chauhan, my lord. Volume 1, 1360, my lord, PDF 1360. Lord, I want your lordships to, my lord, see the contentions raised, because that was not read before your lordships, my lord, and this would really be, my lord, illuminating and will assist your lordships to lay down the law correctly.
1360.
Yes, my lord. 1360 PDF. It is internal page 22 of Shivraj Singh Chauhan. This is the arguments of Dr. Singhvi, which my lords were pleased to, my lord, record. 17.2. My lord, I have marked my copy so that I don't have to, my lord, read everything. And your lords, I leave, my lord, something which is not relevant. Your lordships can trust my discretion on that, my lord. 17.2. There is a fallacy in the assumption that the governor has any locus to direct the chief minister to conduct a floor test to establish a majority on the floor of the House. Next, this court ought not to enforce the direction for convening a floor test, as it will have the effect of short-circuiting, as it was described, the large discretion which is entrusted to the Speaker on the matters of resignation by members under Article 190. Then, my lord, 17.8. The precedent of this court in regard to convening of the trust vote have arisen in the context of fresh elections held to the legislature and not in the context of a running assembly. My lord, Shivraj Singh Chauhan was a case of a running assembly, and in the midst of the, my lord, the government functioning, the then chief minister lost the confidence. This is what your lordships were dealing with, my lord. Now, my lord, kindly come to para 19. Again, my lord, submission. Elucidating on the above submissions, it was urged that the object of exercise undertaken by the so-and-so is to find a way around the two-thirds stipulation contained in the 10th schedule by engineering resignations of the 22 members in a running house. The submission is that if a trust vote were to be held before a decision has been taken by the Speaker on whether to accept the resignation of the members, this will pave the way for the 16 members whose resignations have not been accepted till date to abstain from voting. Their abstention, it has been urged, would alter the strength of the members present and voting, thus modifying the required majority in the House and impacting the outcome of the trust vote. Now, your lordships, my lord, kindly directly go to para 26, my learned senior Mr. Sibbal's submission. Lord, it would be at PDF page 1363. 1363. Mr. Sibbal contends that the observations of the Constitution bench in Nabam Rabia on the authority of governor to order a trust vote to be conducted on the floor of an ongoing legislative assembly are purely omitted. But Nabam Rebia was also an ongoing assembly, not first time government formation. The case before the Constitution bench in Nabam Rebia dealt with a situation where the governor had preponed the date for meeting of the legislature assembly to decide the question of speaker's removal. It was submitted that Nabam Rebia is not a precedent for the proposition that the governor is entitled to require a trust vote to be conducted on the floor of a legislative assembly, which has been duly constituted and is in session. Mr. Sibal submitted that the consequences of upholding the power of governor would be to encourage both the demolition of an elected government and the democratic structures of the governance. Mr. Sibal's submission, in Mr. Sibal's submission, governor would have the power to summon the House where it is not in session. Since under Article 168, the governor is a part of the legislature, if the House is not in session, it is open to a governor to seek a special session where facts indicate that the existing government has lost its majority. But this is in support of what I did as a governor. That if it's not in session and something would turn on his written another argument that no confidence motion was the only way and not the confidence vote by floor test. However, in a similar vein, Dr. Singhvi's submission, Mr. Sibal urged that this course of action is not open to the governor when the House is in session, and in such an eventuality, the only remedy is to seek a motion of no confidence to test whether the incumbent government is possessed of the confidence of the House. With respect to exercise of the power of the governor by calling for a trust vote, it has been submitted by Mr. Sibal that there must exist an objective satisfaction of the governor based on material in his possession. Absent a physical verification, it cannot be said that mere tendering of resignation by members led to valid exercise of power by the governor to call for a trust vote. Here, my lord, withdrawing support from the government. In the present case, the governor had no material to conclude that 16 members had submitted their resignations voluntarily. Legislative history in the country indicates that minority governments have survived, and unless it is shown that mere tendering of resignations actually caused the loss of confidence in the incumbent government, it is not open to the governor to conclude that actions of the 16 members would result in a loss of confidence. Here, they specifically say in writing that we want to withdraw support from the government. My lord, your lordships, my lord, kindly, my lord, then skip my submissions, my lord. I happen to appear for the governor there, my lord. Kindly, my lord, come to 1369, PDF 1369. Para 42.
page?
1369, my lord. 1369. The governor relied upon, my lord, this. Para 42, my lords have. My Lord Justice Narasimha. The letter sent by the governor to the chief minister indicate that the governor relied on the following circumstances in coming to the conclusion that a floor test was urgently required. The receipt of information by the governor that 22 members who had previously supported the incumbent government had submitted their resignations to the Speaker of the Assembly. The members who had tendered their resignations had communicated their decision through the print and electronic media. Copies of the letters of resignation had been submitted by the 22 members to the governor. The 22 members had asked the governor to provide security to facilitate their appearing before the Speaker. Amongst the group of 22 members who had tendered resignations were 6 cabinet ministers whose resignations had been accepted by the Speaker. Now, my lord, may kindly come to 43. It was on the basis of the above material and circumstances that the governor informed the chief minister of his having formed the opinion prima facie that the government had been reduced to a minority in the House, making it necessary to conduct a floor test immediately after the address of the governor at the budget session. Then, my lord, para 44, the action of the governor requiring a trust vote be carried out has essentially been assailed on 3 broad grounds of challenge. It has been submitted that governor had no power to order a trust vote in course of an ongoing legislative assembly or at any rate while the legislative assembly was in session. If the governor did possess such a power, then the exercise of the power by the governor in ordering a trust vote impinged upon the authority entrusted to the Speaker under proviso to Article 190, Subarticle 3B. And 3, the governor had no objective basis or material to form the prima facie opinion that incumbent government had lost its majority in the Madhya Pradesh Legislative Assembly. Now, my lord, questions before the court, my lord, kindly come to PDF 1371, para 46. The present controversy raises two separate but intertwined constitutional questions. First, whether the governor is entrusted with the authority to call for a trust vote in the course of a running assembly. And second, whether the governor exercised this authority correctly. If the governor does not possess the authority, the action of calling for an immediate floor test is ultra-vires and unconstitutional. Alternatively, if the governor does possess the authority to call for a floor test, this court must determine the contours of such power and answer the question of whether the governor acted within these contours. It was briefly contended before us that this court should be wary of entering the realm of politics where no judicially manageable your lordships can skip that. Lord, kindly come to page 1372, para 50. Constitutional role of the governor. But I don't think, my lord, anything more is required to be said by me, except, my lord, very respectfully adopting my lord's judicial determination. Para 50, your lordships have, my lord. Can I read?
Yes.
Para 50. We must consider the constitutional scheme in operation between the state legislature and the office of the governor. As a matter of constitutional principle, the state legislature comprised of the governor and the legislative assembly. The governor is not an elected member of the state legislature. The governor is appointed by the president and is the head of the executive branch in whom, under Article 154, the executive power of the state is vested. While holding office at the pleasure of the president, the governor as a constitutional authority, is not a member of either House of Parliament or the legislature of the state. Thereafter, my lords were pleased to trace the history, which, my lord, with my lord's permission, I may skip, my lord, at this stage. My lord, may not be necessary how the governor as a constitutional head came into being. My lord, please come to page 1375, para 757. The Constituent Assembly thus decided to vest the office of the governor with certain discretionary powers under the Constitution. In taking this decision, the Constituent Assembly was aware that there were certain associated risks in granting the governor discretionary powers, including in question of formation, disruption, and dissolution of democratically elected governments. However, the framers felt that this discretion was necessitated by unique historical factors that existed at the time of adopting the Constitution, and it was hoped that with the maturing of our polity, a level of constitutional statesmanship and trust would paper over the cracks of constitutional choices necessitated by more violent times. My lord, kindly come to, my lord, para 61 at PDF page 1377. Lord, all arguments which are made here were advanced, were present before your lordships, and my lords were thereafter, my lord, pleased to lay down the law. Para 61. The issue of whether a governor can call for a trust vote in an already constituted legislative assembly is not entirely res integra. Before a 9-judge bench of this court in S.R. Bomai, the individual cases which came up for consideration included the dispute emanating from the state of Karnataka. In the state of Karnataka, following elections to the assembly in March 85, the Janata Legislative Party emerged with the majority. Sri Hegde was elected as the leader of the House. Lord, kindly allow me to read these facts. Lord, there is something, Lord, which may assist your lordships. Sri Hegde was elected as the leader of the party and was sworn in as chief minister. Following his resignation, Sri Bomai was elected as the leader of the party and was sworn in as chief minister on so-and-so. In September, there was a merger of Janata Party with Lokdal B, resulting in formation of Janata Dal. On so-and-so, a legislator defected from the party and presented a letter to the governor of Karnataka withdrawing his support from the Janata Dal government. The legislator met the governor on the next day and presented 19 letters purportedly of 17 Janata Dal legislators, an independent and a BJP legislator withdrawing support from the Janata Dal government. On so-and-so, the governor sent a report to the president opining that as a result of withdrawal of support, the ruling party had been reduced to the minority in Karnataka Legislative Assembly and recommended that action be initiated under Article 356 of the Constitution. Because if this is the correct assessment of the governor, there are two options: either go for a floor test or 356, which your lordships have frowned upon. Subsequently, on so-and-so, 7 legislators submitted letters to the governor complaining that their signature had been obtained by misrepresentation and reaffirmed their support to Sri Bommai's government. The state cabinet decided to convene an assembly on so-and-so, and the chief minister met the governor, offering to prove his majority on the floor of the house, if necessary, by preponing the assembly session. In spite of this, the governor submitted another report to the president on so-and-so, and a proclamation was issued under Article 356. It was in this background that 9-judge bench, 391, I have already read, my lord. I'll skip that, my lord. Kindly come to, my lord, 65, my lord, para 65 at 1380, where your lordships are now, my lord, analyzing Bommai's judgment in SR Bommai case. Your lordships have, my lord. In analyzing the observations made by the 9-judge bench in SR Bommai, it is pertinent to remember a proclamation was issued under Article 356. The observation in Bommai can be relied on in determining whether the governor possesses the power to call for a floor test. So this is what, my lord, I was respectfully urging. I can see both, my lord, but can't help it. Power to discerning the subsequent question of whether, when the exercise of such power is appropriate is a distant issue. On a perusal of the above observation in SR Bommai, it is evident that, your lordship's findings, whether or not the Council of Ministers has lost confidence of the House must be determined only on the floor of the House and not by the governor conducting an independent verification. Where the governor has reasons to believe, he is not supposed to pass a judgment. When he has a reason to believe that incumbent government does not possess the support of the majority in the Legislative Assembly, the correct course of action would be for the governor to call upon the Chief Minister to face the Assembly and to establish the majority of the incumbent government within the shortest possible time. An exception to the invariable rule of testing whether the government has the Assembly's confidence or on the floor of the House is envisaged only in extraordinary situations where, because of existence of all pervasive violence, a free vote is not possible in the House. Then 66. As a matter of constitutional law, it would not be correct to proceed on the basis that constitutional authority entrusted to the governor to require the Council of Ministers to prove their majority on the floor of the House can only be exercised at the very inception after general elections are held, and not when the governor has objective reasons to believe that the incumbent government does not command the confidence of the House. Therefore, I said he should not only command the confidence, but continue to command the confidence. That's, my lord, the requirement of democratic functioning. The governor is not denuded of the power to order a floor test, where on the basis of the material available to the governor, it becomes evident that the issue as to whether the government commands the confidence of the House requires to be assessed on the basis of a floor test. Undoubtedly, the purpose of entrusting such a function to the governor is not to destabilize an existing government. When the satisfaction on the basis of which the governor has ordered a floor test is called in question, the decision of the governor is not immune from judicial review. The court would be justified in scrutinizing whether the governor prima facie had relevant and germane material to order a floor test to be conducted. It must be noted that governor does not decide whether incumbent government commands the confidence of the House. The purpose of holding a floor test in the Legislative Assembly is precisely to enable the elected representatives to determine whether the Council of Ministers commands the confidence of the House. That verification is not conducted by the governor. The decision in SR Bomai, in fact, held that recourse to the power under 356 was not warranted in a situation. Your Lordships can, my lord, skip the rest, my lord. Now, para 68, your Lordships were pleased to reject the argument. The argument was that the exercise of power by the governor under Article 174 and 175 should also be based on aid and advice. Your Lordships were pleased to, my lord, reject that submission. My lord, I am not, my lord, troubling your Lordship with that, my lord. Now, my lord, 69 at page 1383. Lord, judgment after judgment, it is settled, my lord. Please allow me to place Nabam Rebia, my lord, only.
Just the para 71 and 72 also.
Yes, I'm coming to that. My lord, 70 also, my lord, 70 according to I'll read 70, my lord. We are unable to accept the submission of that the observations of the Constitution bench in Nabam Rebia are obiter. The observation in Nabam Rebia are consistent with the formulation of principle in the 9-judge bench decision in SR Bomai, as we have discussed earlier. Please note, my lord, the power under Article 174 of the Constitution to summon the House and to prorogue it is one which is exercised by the governor on the aid and advice of the Council of Ministers. But in a situation where the governor has reasons to believe that the Council of Ministers, headed by the Chief Minister, has lost the confidence of the House, constitutional propriety requires that the issue be resolved by calling for floor test. The governor, in calling for a floor test, cannot be construed to have acted beyond the bounds of constitutional authority. And, my lord, loss of confidence mean in a running assembly. Now, my lord, your lordship may, my lord, kindly 71. The powers which are entrusted to constitutional functionaries are not beyond the pale of judicial review. Where the exercise of discretion by the governor to call for a floor test is challenged before the court, it is not immune from judicial review. The court is entitled to determine whether, in calling for the floor test, the governor did so on the basis of objective material and reasons which were relevant and germane. These are the potent words used by our lordships. It should not be irrelevant material or something completely not germane to the issue. The exercise of such power is not intended to destabilize or displace a democratically elected government accountable to the Legislative Assembly and collectively responsible to it. The exercise of the power to call for a trust vote must be guided by the overarching consideration that the formation of satisfaction by the governor is not based on extraneous considerations. So, my lord, when there are extraneous considerations, your lordships would step in and exercise the power of judicial review, and extraneous would mean completely irrelevant and not germane to the issue, namely whether the governor would be justified in forming an opinion or entertaining a doubt about the government having lost the majority support. If the documents are not irrelevant or not germane, then, my lord, perhaps your lordships may not take a second guess on the basis as to what your lordships would have perhaps perceived the situation to be capable of. Lord, kindly, Lord, para 73. Para 73, my lord.
Yes.
And I have something to say, my lord, on that no confidence, because that was not argued by any one of us, my lord. In a situation where the House has been summoned following the aid and advice of the Council of Ministers, the position would be more nuanced in the sense that the remedy of a no confidence motion would be available to any segment of the legislature seeking to espouse the view that the government has ceased to command the confidence of the House. When the government calls for the session being called, in exercising the constitutional authority to demand a trust vote, the governor must do so with circumspection in a manner that ensures that authority of the House to determine the existence or loss of confidence in the government is not undermined. Absent exigent and compelling circumstances, there is no reason for the governor to prevent the ordinary legislative process of no confidence motion from running its due course. Lord 74. In discharging this crucial role, it is necessary that the governor bear in mind that the purpose underlying the entrustment of the authority to require a trust vote is not to displace duly elected governments, but to intervene with caution when the circumstances which are drawn to the attention of the governor indicate a loss of majority. Circumstances should be present before the governor. This power is granted to the governor to ensure that principle of collective responsibility is maintained at all times and must be exercised with caution. The circumstances on the basis of which the governor forms a prima facie opinion leading to a communication requiring a trust vote in the Legislative Assembly must be of an objective nature. The decision of the governor to do so is not immune from judicial review and must therefore withstand the ability of being scrutinized on the touchstone of circumstances. Again, my lordships are careful in saying being relevant, germane, and not extraneous. I had 47 members before me saying that we don't want to support this government. We want to withdraw support from this government. That is itself an enough ground in my respectful submission. Lord, kindly, my lord, thereafter see, your lordships were pleased to, my lord, para 77 at page 1386. Your lordships were pleased to record, my lord, several past cases where the governor either decided to direct floor test, parties came here and your lordships did not intervene, or governor was not directing floor test, parties came here and when required sitting at midnight, your lordships directed that immediate floor test, and the only purpose was, I'm sorry, my lords are typing. I'm sorry,
Yes.
The object of my lord was, no, your lordships may complete. I'm sorry, no, that there is no time for either pressure, threat, coercion, violence, allurement, etc., etc. Whatever is the will should be reflected at the first available opportunity. Therefore, your lordships, my lord, sat at night in case of Karnataka. There are several such instances. And therefore, I am not reading, my lord, but there are large number of cases, my lord, which your lordships were pleased to reproduce. And thereafter, say at page 1389, my lord. At the para 78, at the foot of 1388. The idea underlying the trust vote in the ultimate analysis is to uphold the political accountability of the elected government to the state legislature. So therefore, I was saying that you should not only command the majority support at the time of formation of the government, you must continue to command that. That's the democracy. Assertion of accountability is a mirror image of collective responsibility of the government to the legislature. The requirement of the trust vote fulfills that purpose in the present case. The present controversy has shown a light on the often fluid allegiances of democratically elected representatives. This is a matter of their conscience, and the court expresses no opinion on the matter. However, it is important to note that in directing a trust vote, the governor does not favor a particular political party. It is inevitable that the specific timing of a trust vote may tilt the balance towards the party possessing a majority at the time the trust vote is directed. All political parties are equally at risk of losing the support of their elected legislators, just as the legislators are at the risk of losing the vote of the electorate. This is how the system of parliamentary governance operates, and the learned senior counsel on both sides of the dispute congenially admitted that the outcome of the trust vote is the ultimate litmus test for the legitimacy to govern. However, we note that where the evidence indicates that circumstances of violence and coercion exist that would undermine a free and fair vote in assembly, the governor and the court must take measures to ensure that the sanctity of the trust vote is maintained. In circumstances as they have emerged in this case, the exercise of authority by the governor was based on circumstances which were legitimate to the purpose of ensuring that norm of collective responsibility is duly preserved. There existed no extraordinary circumstances for the governor to determine that the trust vote was not the appropriate course of action on 16th March. So it is only in extraordinary circumstances that there would be a departure from floor test rule. Otherwise, floor test is the rule. Well, that's what, my lord, the test your lordships were pleased to lay down. Because when we say, my lord, that defection is the highest political sin, Lord, running a government after losing the confidence of the electorate, namely the House, is a larger constitutional sin to which governor should not be a party. Lord, kindly last, my lord, para 50, para 80, at page 1390.
1 minute.
Lord, this is
1 minute.
I'm sorry. Para 79, my lord, the submission that short-circuiting the speaker's power, that governor, by asking for the floor test, has short-circuited, my lord, the speaker's power, and your lordships are, my lord, dealing with that at para 18, 80, my lord, 80. It is trite law that neither the governor nor, for that matter, this court has the power to impinge upon the authority of the speaker to take a decision on the above issues. The issue, however, is whether the convening of a trust vote has to be deferred until such time as the speaker has taken a decision on whether or not to accept the resignation, and if so, the consequence of the members departing from the fold of the party on whose ticket they were elected under the 10th schedule. Holding of a trust vote operates in a distinct field from the issue as to whether one or more individual members of the Legislative Assembly have embarked upon a voluntary act of resignation or have incurred the wrath of 10th schedule. Holding a trust vote is necessary to ascertain whether the Council of Ministers headed by the Chief Minister has the confidence of the House. The continuous existence of that confidence is crucial to the legitimacy and hence survival of the government. I could never have put it, my lord, like this. Continuous existence of that trust gives you the legitimacy in democracy. It is a matter which can brook no delay, since the authority of the government presided over by the Chief Minister depends on the Council of Ministers continuing to have the faith of the legislative body as a collective entity, particularly where the members resigned in an expression of lack of faith in the existing government. The convening of a floor test is the surest method of assessing the impact of resignations on the collective will of the House. The consequence of the acceptance of a resignation is to reduce the numerical strength of the House. Until the resignations are accepted, members who have resigned continue to be reflected in the strength of the House, having regard to the language which has been employed in Article 193(3)(b). Whether in a situation such as the present, an elected government is entitled to continue despite resignations of 22 of its members has a significant bearing on the issue of confidence. But if this is right, then the governor is right that if 47 people want to withdraw support, it is the most relevant fact to be considered while deciding the floor test. Nothing beyond that. Governor does nothing beyond that. Neither the governor nor, for that matter, the court can entrench upon the power of speaker, but the pendency of proceedings before the speaker cannot be a valid basis not to have the confidence of the House in the government determined by convening of a floor test. Added to it is a factual circumstance in the present case that the speaker accept. No, that's on the facts of the case. Now, kindly allow me last para 81. We have highlighted above factual scenario only to emphasize that convening of a trust vote is of crucial importance to affirm fundamental values of the Constitution, namely abiding by the rules which govern a parliamentary democracy. The fundamental precept of parliamentary democracy is that government owes collective responsibility to legislative assembly, and as a collective body, the legislative assembly is entitled to hold the government to account. The ultimate expression of accountability is the exercise of or the lack of confidence in the Council of Ministers. We are therefore unable to accept the submission that the holding of a trust vote would short circuit the jurisdiction of the Speaker. My Lord, rest, my Lord, may not be relevant, my Lord. Now, my Lord, last. My Lord, kindly take my Lord, propositions, my Lord. My Lord, para 7. I'll just quickly go through, my Lord. There are only 2 pages, my Lord, left. Para 7. There is one more reason why governor cannot preempt the decision of the speaker at the stage of directing. Your lordships may, my lord, read them, my lord. I am not reading it, my lord, for the sake of convenience, my lord. 8. The governor, if satisfied based upon the material available, your lordships can skip that. My lord, kindly come to 10. The governor in the instant case did not recognize the split as alleged. If the governor would have recognized the split in Shiv Sena as alleged, he would have directly called Sri Eknath Shinde to take oath. There was a split. The governor merely, based on objective material before him, none of which is disputed on facts, formed an opinion as to the doubt about as to whether Sri Thackeray enjoys majority in the House, and considering the threats and violence, he should be immediately called upon to face the floor test. Now, this is 11 is important. The argument was that floor test could not have been ordered because they, this side and other independents, etc., who withdrew support from the government, they should have gone for no confidence motion. And this is a new point, my lord, which I would be urging for your lordship's consideration, not argued, my lord, so far. First of all, my lord, whether it is a floor test, which is a motion of confidence, or a no confidence motion, my lord, which is negatively worded, the result is the same. And therefore, there can never be a ground to invoke your lordship's equity jurisdiction in a 226. Floor test also, the numbers will be counted and people would decide whether I have the majority. In no confidence, numbers will be counted and members would decide whether I have the majority. But there is something more than that. Lord, please come to PDF page 40 of Convenience Compilation 3C. Lord, the provision in the Maharashtra Legislative Assembly rules regarding no confidence motion. Lord, your lordships are confronted with a situation where the governor is receiving representations that we have withdrawn support, we want to withdraw support, etc., etc. I'm not repeating. There is a threat of violence. There is, in fact, violence. Attacks are taking place at the houses. And now, my lord, the submission is that you should have allowed the no confidence route rather than directing a floor test. Please see, my lord, now page 40 of, my lord's Convenience Compilation 3.
3C.
CC3, my lord, Convenience Compilation 3. My lord, that is part of rules of Maharashtra Legislative Assembly rules. Your lordships have said, my lord, please bear in mind that such floor test cannot brook any delay. And why is this reliance on no confidence motion? Maybe they wanted more time, which the governor prevented them from doing. Para 90, rule 95. Your lordships have that, rule 95?
Yes.
Well, 2 things. I'll say at the outset and I'll read this. First,
3C.
First, any member can move a no confidence motion only when House is in session. Not otherwise. House was not in session. Number 2, it depends upon the discretion of the speaker whether to allow the motion to be placed or tabled or not. It's not a right. So again, I'll be dependent upon the discretion to be used by the speaker if I'm the elected representative. This is what, my lord, therefore, governor says that no, you hold a session. Kindly see, my lord, rule 95. A member who desires to move, your lordships have them. The member who desires to move for leave to make a motion expressing want of confidence in the Council of Ministers, or a motion disapproving the policy of the Council of Ministers in a particular respect, shall give written notice of such motion. If the motion is admitted by the Speaker, leave to make the motion may be asked for. So first, he can sit for 1 week to decide whether to permit this or not. But if he admits, then the members will seek leave to make the motion for on such day not later than 2 days after it is admitted. If the assembly is in session, as the Speaker may appoint, after questions and before the list of business for the day is entered upon. So when the assembly is in session, this can be done with the Speaker. There is no time limit fixed. He can decide to admit it after a week. And thereafter, if the assembly is in session, the members can say 2 days. Now, my lord, further, provided that, your lordship said, my lord, the next page, provided that if the notice of such motion is received when the assembly is not in session, the leave to make the motion may be asked for on a day not later than 2 days after commencement of the session, as the Speaker may appoint. So the next session may be after 15 days, after 1 month, after 5 months. We do not know. Your lordships are deciding this constitutional principle, that whether the governor was right in directing summoning of the House for floor test, and they are saying that no confidence motion was the route, meaning thereby this threat, allurement, violence, etc., continues, and the governor's satisfaction that prima facie the government has lost confidence would continue without any legitimacy. My lord, borrowing your lordship's very, my lord, pertinent expression. After the member has asked for leave of the assembly to make the motion, the Speaker shall read the motion to the assembly and request those members who are in favor. That's the procedure, my lord, how the motion would be passed or failed. So, my lord, this is no remedy in fact situation like this. Because the taste, my lord, right from the state of Rajasthan till Shivraj Singh Chauhan is, it cannot brook any delay. Lord, last 3 points. Lord, last page of my proposition, my lord. Lord, 12 I have already covered. 13. Lord, decision of the governor to direct floor test is not to be based on aid and advice. Lord, para 28 of my detailed submissions, I have already covered that. Lord, I have that's what your lordships have held in Shivraj Singh Chauhan. After the decision of Sri Uddhav Thackeray not to face the floor test by tendering resignation, the only option for the governor was to call Eknath Shinde, who could prima facie satisfy the governor that he can form a stable government. Another option was 356, which is frowned upon, and nobody, that has to be the last resort. And how, that happened, please come to, as a last submission, my, written, the documents which I have placed. The governor received 2 letters that now Eknath Shinde has the majority. And, another very risky argument which Mr. Sibal made, that why did the governor call Eknath Shinde to form the governor? And why not the president of the party was consulted? My lord, the governor knows only the elected leader of the house. He is not concerned with political parties. There are political parties where leader of the house is in fact the leader and president is not controlling him from somewhere else. Governor has to contact the elected leader of the legislative party. When he is shown, my lord, I'll show, my lord, those documents. There are 2 letters, my lord, I'll show that document. Because, my lord, every party has a different structure. Kindly see, my lord, the mischief in this argument. I'm saying argument, not mischief in making of the submission. My lord, mischief. I'm sorry, my lord. I thought, my lord,
They're relieved with your clarification.
No. It was not correctly worded, my lord. The potential mischief if this argument is, my lord, accepted. That's what I wanted to convey. My lord, every party has a different party infrastructure. For example, in some parties, The highest authority is the General Secretary. There is a Politburo in Communist Party. General Secretary is the highest authority. In some, my lord, there is a body, 5 people, my lord, committee or something. In some, there is a president. There may be a dispute who is the president. Governor would not enter into that. Governor would say that who is the leader of the legislative party. Governor would deal with only leader of the legislative party, and Mr. Uddhav Thackeray, who did not face the confidence and therefore he resigned, is not even a member of the Legislative Assembly. My lord, kindly see page 47, PDF 47 of the governor's compilation. My lord, this is the
PDF page? Sorry.
page 47 of governor's compilation. My lord.
Signed by 34 members. Para 2. Para 3, letter of 21/6/22 addressed by Mr. Shinde to the Deputy Speaker. And lastly, the
apprehension of MLAs is also fortified by the letter of leader of opposition,
That's in
who
the
has in
context
fact
of
provided, no, kindly further, provided links to videos where Mr. So-and-so has openly stated that dead bodies would come. And I would, my lord, earnestly urge, my lord, not to condone this. My lord, this is a threat in public platform. My lord, let us not, my lord, lessen the gravity of it. It's a very serious thing. I leave it at that. I leave it at that.
Law and order situation.
I leave it. No, my lord. It can be law and order situation also, but if that law and order situation is being created to bring pressure on the legislative process, then it's not just a law and order situation. It is one of the major consideration for the governor that yes, he seems to have lost majority, and now open threats are being administered that you come in our fold, or my lord, honestly request your lordship, my lord, that it cannot be taken serious, my lord, lightly by the constitutional.
But that
I leave
would
it
be a
at
ground for unseating a government. I mean, ultimately, that somebody who makes
I'm
that
sorry.
threat is
Sorry.
subject to section 156(3), is subject
I'm
to
sorry.
an FIR. You can do what you want about that.
Kindly allow me
threat
to,
which is given.
my lord, put it differently. My lord, that's where the perception differs. If I say that because somebody is threatening, you face the floor test, then your lordships are right. But when I have the letters that we want to withdraw support and we are being threatened, then it's not that reason. That's the ground, not the reason.
We'll hear what Mr. Sibyl and they have to say in rejoinder, I think.
Yes, please. My lord, one clarification, not on the merits of the case. I checked up the couplet, my lord, which I started with.
This was not Barilvi.
Wasim, it's by Dr. Bashir Badra. They are contemporaries.
Oh.
Their style of writing is very similar. It's likely to mislead, my lord, every reader. It's by Dr. Bashir Badra. He is no longer there, my lord. Wasim Barilvi Sahib is.
You're giving credit where it is due. That's
Yes, my lord. When especially when he is not. Dr. Wasim Barelvi is also, my lord, he is alive. Dr. Badra, my lord, passed away recently. But contemporaries, same age group.
Thank you, Mr.
Obliged to your lordship, my lord, and sorry for, my lord, exceeding the, but
No,
your lordship.
You also asking questions, quite a few of them. Thank you, Mr. Solicitor.
Obliged to your lordship.
What I've done, my lords, I've filed a rejoinder of submissions, my lords, before your lordships.
Has it been circulated?
It was circulated, my lords. We've hard copies, but it was circulated.
Upload हुआ है?
Where?
Upload नहीं हुआ.
But please airdrop it.
That'll be condemned.
It's been circulated.
It has been circulated.
It's been circulated to your lordships, Malas,
At 9:50.
in the morning itself.
Quarter
Yeah.
past 9.
Yes, ma'am.
That's why it's not here.
That's correct.
Other side, the rejoinder submissions given are lengthier than my reply. Other light, you need not respond to that. It was a fun.
I have to respond to more weighty things than
For 9?
the pages of my rejoinder. Malas, your lordships may just, at the moment, Malas, not deal with this document. It will come to you. Let me just broadly tell your lordships, Malas, what we have to meet and what the issues are. Malas, I think that we seem to have been, we are somewhat innocent of the manner in which people are represented in the House and who a legislator owes his duty to. Well, as your lordship knows that under the 1950 Representation of People's Act, Mullahs, you have a delimitation commission. And in each state, a delimitation takes place and the territorial constituencies, Mullahs, are carved out. So the elections takes place with respect to those territorial constituencies in each state, and the number is already, Mullahs, fixed. So, Mullahs, under the Representation of People's Act, first under the Constitution, under Article 170, people are directly elected from the territorial constituencies. And, Mullahs, there is a process by which, Mullahs, they are elected. That process is also, Mullahs, elaborately set out in the conduct of election rules. First, there's a nomination that takes place, Mullahs. The nomination takes place pursuant to your party nominating you and giving you the symbol on the basis of which you go to the returning officer and say, I am the nominee of the party and this is my symbol, which represents the party. After which, Mullahs, the election takes place. And when the election takes place and the votes are counted, Mullahs, the returning officer then gives you a certificate saying that you have been elected from this party. A copy of that is sent to the Election Commission. It's all set out here, so you'll watch it. At the moment, I'm just broadly. A copy of that is sent to the Election Commission, and the Election Commission conveys that to the Speaker of the Assembly. What is it that I'm trying to say? The only identity of a legislator recognized in the House is that he is a member of the party. He has no other identity. Two members, 3 members, 20 members, 34 members can't have an identity outside of that. That's the basic constitutional question. Give your lordships an example, Let's forget about 34. A small party in Goa has 5 members. 2 of them go to the speaker, to the governor, and say, you know, I'm not going to support this government. And those 2 mothers actually tilt the balance and the government can fall. So the governor will call a floor test.
Sorry?
Will the governor call a floor test? Forget majority, even the minority cannot topple the government, if this is the procedure in law that we have to follow. We are back to Ayaram Gayaram. Why? Because you say, now your political affiliation doesn't matter. What matters is numbers. Democracy is not about numbers. It is numbers within a constitutional framework. What the legislators, the speaker, the governor recognizes are political parties. And you are a member of a political party, nothing less, nothing more. You have no other identity. And I tell your lordships why I'm saying this. How are governments formed? Sarkaria Commission, remember, Maharaj? Largest single party who has a majority on the floor of the House, the governor will call him to form the government, the leader to form the government. If that's not possible, comes the second, and that's political party now. Second, pre-poll alliance of what? Of political parties. That's the second, if they form the majority. Three, post-poll coalition.
What is the first?
Single largest
Yes.
political party. Second is pre-poll alliance of what? Of political parties. Could be one, it could be two, it could be three.
Which is the third one?
Third is post-poll coalition, which is what the Uddhav government was. Post-poll coalition of political parties. And the fourth is post-poll alliance of political parties. The governor, under Article 168 of the Constitution, is not a member of the Legislative Assembly, but he is part of the legislature. He can't recognize anybody other than political parties. That is the constitutional fundamental framework within which the House functions. That's why we did away with Gayaram, Ayaram.
Lastly, the governor is not part of the...
He is part of the legislature, but not a member of the Legislative Assembly. So he only recognizes, because he is part of the legislature, the political parties, the legislature parties. That means my identity is associated with my party in the House. I have no separate identity. Otherwise, mothers 10 from one party, 2 from another party, 3 from another party will go to the governor and make the government fall. And then my learned friend's argument, see, the governor is fully satisfied that you have lost the confidence of the House because 10, 2 and 3, along with the present dispensation, make the majority. So you back on Ayaram Gayaram days? The whole purpose of the 10th schedule is to get rid of it. Numbers in the House will not make governments fall. It is the alliance of parties in the House that will make the government fall. And that's the application of mind of the governor when he decides to ask for a trust vote. See the havoc it will cause. All you need to do is to look up numbers, and they will say, Malats, on public platforms that it is a call of conscience. Malats, we know the extent of their conscience. They'll go to the governor and say, see, we give you the numbers now. This is my letter to you. We are now the majority. This government, this chief minister has lost the confidence of the House. See the numbers. And it will be argued that, look, it's demonstrated that it doesn't have the majority and therefore hold a floor test. You see the consequences of this argument on the democratic polity of this country. That's one issue, Malats, I will deal with. I just want to point out. Number 2, even more important, which is something that I mentioned earlier also, and in detail, Malats, in my note, and which they did not comment on at all. All the council have not commented on the concept of the whip. In fact, I was really surprised when my learned colleague, Mr. Kaul, gave to your lordships a letter of Mr. Sanjay Raut. Your lordships will remember that, saying, no, actually it is the legislative, it is the leader of the house who appoints, it is the leader of the house who appoints the whip. Well, let's just kindly have a look at that letter. It is the last page of the submission, Maharaj. That was, I just handed to your lordship.
6th July 22.
Yeah, just see, it was a very interesting letter. Now, your lordship sees this. This is to the Speaker of the Lok Sabha. Lordship sees that. And 13th June 2019, which was handed over. Yes.
No. This is Baba Sahib appointing him.
July.
That's correct.
That is Rajya Sabha.
Kindly, no, this, one second. This is by Eknath.
No, this is by Bala Sahib
Lok Sabha.
appointing Rao.
Yes, now see what is the last page at page 44. Sanjay Raut writes to Malad, the Speaker of the Lok Sabha. That's what he pointed out. Have that document?
Yes, yes.
Says, respected sir, it is to inform you that Shiv Sena Parliamentary Party has nominated Rajan Vikhare, MP, as Chief Whip in Lok Sabha in place of Bhavana Gawali with immediate effect. Signed, Sanjay Raut, leader of Shiv Sena Parliamentary Party. Correct, Maharaj? Now just see the previous page. Sanjay Raut is a member of the Rajya Sabha, not a member of the Lok Sabha. He is appointing the leader in the Lok Sabha. Appointment of Shiv Sena Parliamentary Party leader for both houses, Lok Sabha and Rajya Sabha. Dear sir, Shiv Sena has the strength of so much in the Lok Sabha. Previous page, Maharaj. Vinayak Bhaura Raut is the Shiv Sena group leader in Lok Sabha, and Sanjay Raut represents Shiv Sena as group leader in Rajya Sabha. In addition to the above, I hereby appoint Sanjay Raut, member of Rajya Sabha, as Shiv Sena Parliamentary Party leader for both the houses of Parliament, Lok Sabha, Rajya Sabha, as a facilitative measure. May I therefore request you, esteemed office, to take note of the same and communicate accordingly. And Maharaj, I gave to your lordships chapter and verse. Erskine May, all the authorities, Maharaj, as to how it is the political party that appoints the whip in the house. Paksh Pramukh. And this whole argument was jettisoned by showing this document, saying, see, Eknath, Sanjay Raut is appointed. He's not even Maharaj, a member of the Lok Sabha. He is empowered by the party. So this whole argument that I sat in Assam, appointed Gogavale as the whip. Where does that come from in constitutional terms? 34 of you sitting in Assam in the lap of the BJP will appoint Gogavale as the whip and then come to court and say, look, we have already removed you. Under what power?
Sorry for interrupt. This may not be relevant for the.
Sir, if you don't mind, sir,
rejoined
throughout, sir, I mean, I really will appreciate. You people have, my colleagues have answered for 5 days. I have not uttered a word throughout. So please allow me to at least argue in my own way.
Saturday, Sunday. But appointment of whip in Rajya Sabha, Lok Sabha, it would never be over. We curtailed our arguments. In a rejoinder, my lord, appointment of whip in Lok Sabha.
Well, if you want, I can sit down and the court can decide, since you are the master of the ceremonies here. So, Maharaj, because that was an argument made, Maharaj, because that justifies, what they say, that justifies the fact that Gogavale is the whip and he issued directions and he has to be obeyed. Maharaj, till The fourth, who was the political party recognized in the assembly? Shiv Sena. That was a political party. Who was the whip, Malaj? Sunil Prabhu. So the second submission that I wish to make to your lordships is...
First and second are more or less both men. Basically saying that whips are actually appointed only by the political party.
That's right.
That's it's a simple point.
That's simple, very simple point. It's appointed, so Malaj, the whip has to be obeyed. Sunil Prabhu had to be obeyed.
You made this point.
Yes. On third, Sunil Prabhu issued a whip that you cannot vote for the BJP candidate as speaker. Whip was disobeyed. He cannot appoint himself as the leader because Ajay Chaudhary became the leader on the 21st of June itself when we removed Eknath Shinde. That removal of Eknath Shinde and appointment of Ajay Chaudhary was conveyed to the Speaker of the House. The Speaker of the House recognized it. So how could the governor call Eknath Shinde? Who is Eknath Shinde? I'm talking in constitutional terms, Malaj. Argument is Eknath Shinde was the group leader. Where was it? Under which law? Which group? You can't arrogate yourself the powers of the party. Sitting in Assam, being entertained by another party, publicly saying that another party is fully supporting me, and changing the constitution of the House as if you are the political party. That's the second, which I will argue, Malaj. I won't take too long, Malaj, just so that we reduce the level of controversy. Number three, my learned friend, my colleague, Mr. Kaul, Malaj, argued that I am the party. He says, I am the party. I am the Shiv Sena. Well, on what constitutional basis can people with 34 members say they are the Shiv Sena? Are they recognized by the Election Commission as the Shiv Sena? Shiv Sena is a registered political party with a political leadership, Malaj, intimated to the Election Commission under Section 29A of the Representation of People's Act. The moment the recognition takes place under Section 29A, that is the decision of the Election Commission, which is final. That decision was not overturned by anybody. When all this happened till the 4th of July. So, Malaj, how can Eknath Shinde's group of 34 say, I am the political party? It has no constitutional basis. And for 5 days we have heard this, Malaj. I am not saying that I have split. I am not saying that I am the faction. I am saying I am Shiv Sena. So if I say I am Shiv Sena, I am Shiv Sena in constitutional terms. Cannot be. Next point, Mullahs, which is even more important. Mullahs, your lordships will remember that under paragraph 3 of the 10th schedule, which was deleted later by the 91st constitutional amendment, the expression is that if there is a faction in the legislative party arising out of a split in the political party, and that faction represents 1/3 of the legislative party, then that will be a valid defense against a disqualification petition. What it is. So what is the expression used there? I am a faction of the legislative party, resulting from a split in the political party. Right, Manoj? Now, he says that we 34 are the political party. That's his case. He says, I'm not a faction. There's no split. But Manoj, when he goes to the Election Commission, what does paragraph 15 say? That if there are two factions of a political party who claim to be that political party, it doesn't use the word split. Then the commission will decide which is that political party. So before you, they say, I am the political party. And before the election commission, they say, I am a faction. Because if he is the political party, he need not go to the election commission. Why is he going to the election commission? He says there's no difference between the legislative party and the political party, which is Malaj, a mockery of the 10th schedule itself, because the whole purpose, Malaj, of differentiating was that members of the legislative party will not do acts which amount to voluntarily giving up membership of the party or vote against the whip, which will result in defection. The whole purpose of the 10th schedule is to differentiate between the legislative party and the political party. And the whole argument is there is no difference between the legislative party and the political party. I am the political party. But if you are the political party, why did you move the election commission? Well, let's take, for example, 3 people out of 5 belonging to the Congress party. They are a majority. They go to the governor of Goa and say, I am the political party. We are the majority. Topple this government. Numbers are stacked against, government will be toppled. They will never go to the election commission. Why? Because there is the Congress party outside. What will the governor do? Governor, you think, Malaj, on their logic, governor will have to call a trust vote, because the best way, Bomai says, the best way is to find out from a trust vote. Malaj, all judgments of law are contextual. Unless there's an underlying basic principle, like basic structure. Otherwise, all judgments are contextual. When your Lordship's Malaj decided on Shivraj Chauhan, the context was what? 22 resignations. Context.
And 6 were accepted.
Yes, 6 accepted. Not only that, 13th of March, governor tells him to hold to call the assembly, which is called on 14th March, and hold the trust vote on the 14th. The chief minister says, no, I adjourned it. He didn't put it in the agenda. He adjourned it to 26th March, if your Lordships will remember. So he adjourns it to 26th March. Then the petitions are filed. Saying, how have you adjourned it to 26th of March? Because the governor told you, matter comes to this court, and your Lordship says, look, this is the best, because all those 22 letters of resignation are with the governor. Then your Lordship said another thing, which I'll read later to your Lordship. Your Lordship said, as far as the disqualification is concerned, who stopped you from disqualifying? That's paragraph 82 of your Lordship's judgment, where your Lordship said this. Nothing stopped the governor, the speaker to disqualify if he wanted to disqualify. But once people have resigned, so it was in the context of 22 resignations, context of 6 of them having been accepted on the 14th of March itself on the advice of the chief minister. Speaker accepts them. And your Lordships ask the question, what's the difference between those 6 and the other 16? There's no difference. They have come, the signatures are there, they have given to the governor. What else can we do? And who stopped you from disqualifying? Whereas what has Shivraj Chauhan got to do with this? This matter? There's no bearing. We're dealing with what? We're dealing with 34 people, which is a faction. They can't not say they're not a party, that they are the party, because they can't be the party. It's a faction. How does the governor recognize a faction? Under what constitutional parameters does the government say, I recognize you, and therefore I'll call a floor test? It's not a game of numbers. So if you actually hold their submissions to be correct, you're bringing back the regime of Ayagam Gyaram, because anybody can collect the numbers in the manner that they are collected nowadays, whisk them away to any other state, keep them in comfort. I don't want to use a stronger word. And then, well, let's come back and topple the government. And you'll have no recourse. Next is even more important.
You're saying 3/4 is also a split.
Yes. Exactly.
According to you, even 3/4 will be split.
That's correct. That's still a faction. That's why 3 was eliminated. You can't have sort of factions moving out, because we know how these numbers are collected. Then I remember I showed you Kuleep Nayyar's case, where all that was set out. More important, whereas they have only on the today in court argued that they are the party. Not a single document, right from the 21st of June, till they file the petition, even there they do not say, till the 19th of July. Whole argument is, I am the party. Where have you said ever that you are the party? Never. Not a single document. This is a mockery, Malaj, that's happening in our country. And I said, Malaj, and I repeat it, it's not about Maharashtra. It's about Meghalaya, it's about Manipur, it is about tomorrow Uttar Pradesh, it is about anything can happen anywhere if you allow this to happen. It's about our future. So, Malaj, they never say that they are the party. Even if that, your ladyship will remember that document on the 28th of June that was read. First of all, Malaj, let me disabuse you of this whole thing about violence. On the 27th, when we moved this court, they moved this court. My learned friend was there, I was not there. On 27th, Malaj, a statement was made by Mr. Kaushik, who was Mr. Chitnis, yes, saying that Mr. Chitnis, learned counsel for the state of Maharashtra, states that adequate steps have already been taken, and the state government has further ensured that no harm is caused to the lives, liberty, and property of the 39 MLAs and their families. This on the 27th, and the governor is arguing, Malaj, on the 28th there was a danger, there'll be dead bodies, it will be post-mortem. When on 27th a statement has been made by Mr. Chitnis, who represents the Maharashtra government, under the supervision of the Supreme Court, can anybody, Malaj, say that, look, dead bodies will be sent for post-mortem? This is the 27th June order. And that was repeated again and again and again. Malaj, if I were to go to the newspaper reports and what they have said in Assam, Malaj, that your lordships are not going to enter into that. And Malaj, the unfortunate part of it, and I say unfortunate, Malaj, deliberately, the very thing that we wanted to prevent happened. When your lordships did not grant us stay, fine, no issue. But we went to the election commission, we told the election commission that, look, these are the very 39 people whose candidature as a member of the Legislative Assembly is subject to the Supreme Court. So please don't decide this matter till that is decided. No state did not mean that you decide no matter what happens. They misinterpreted that order deliberately, not the commission, but the other side. And said, no, Supreme Court has said, no, stay, you have to decide. And then what did the election commission do? On the basis of these 39, they've got the symbol. Only on the basis of these 39. So what are we here today? Today they argue, now we are the party, because you've got the symbol. So, Malaj, on 27th of June, we are put in difficulty. 29th of June, we are put in difficulty. And then in September, when your lordships pass this order, they misinterpret it. 27 September. The next point, Mullahs, your lordships will have to consider, and I'll be very short, Mullahs, tomorrow so that we can finish this quickly. Next point is, Mullahs, they have been saying that under the mandatory rules, 7 days notice ought to be given. Correct, Mullahs? How many days notice have they got now? They have not filed reply till date. 9 months? And Mullahs, I asked myself this question. When this court said, don't, is it fair of the court, I'm sorry to say, if that is the mandatory rule, then you should have said 7 days from the date. Shorter period. 12th date, and that also in the interim. And 9 months have passed. And then Mullah's argument is this is a fait accompli. See the arithmetic. Even if the 16 had been disqualified, you would still be in minority. And I think Mr. Salve was right. That's all speculation. What would have happened, what would not have happened. Maybe the others would have voted in our favor. But that's all speculation. Your lordships are not concerned about that. What the arithmetic is. And see the injustice caused to us, Mullahs, in this process. So they don't file a reply. Now they say, go back to the speaker. And Mullahs, there is no one fact which is not admitted on both sides. That they have 34, majority in the legislative party, admitted. We don't deny it. That they were sitting in Assam, they admit. That they sent that resolution throwing out Sunil Prabhu, they admit. That they appointed Gogavale, they admit. And whereas what's interesting is in that resolution that they sent where your lordship said the only 2 prayers that are made are that Gogavale is appointed. But see the language as far as Eknath Shinde is concerned. He continues to be the leader. The word continue. But how did they realize that the word continue has to be used? Because we had removed him on 21st. And on 22nd, they dated the letter 21st and sent it to the speaker, received by the speaker on the 22nd at 11:30 a.m. So they knew that Eknath Shinde had been removed. Otherwise, they would have said that Eknath Shinde is the leader. But they said, no, Eknath Shinde continues to be the leader. And they backdated that document. So, Mullah, that's not disputed. That we called a meeting on the 21st, 22nd, not disputed. We told them if you don't attend, consequences will follow, not disputed. On 24th, we had a council meeting, not disputed. They said, but nobody called the council meeting. We'll hold a parallel meeting of our own, not disputed. What is disputed? That on the 28th, the governor received these documents which have been placed before your lordships, not disputed. That he called for a floor test, not disputed. That he resigned, the chief minister, then chief minister resigned, not disputed. That he went to the governor along with Mr. Fadnavis, not disputed. That he was sworn in, not disputed. That there was a trust vote, and we issued a whip, not disputed. That they voted against the whip, not disputed. What is disputed? Nothing is disputed. From the beginning to the end, Mullahs, the whole process is clearly political. Clearly political. And whereas I want to know, your Lordship knows about it, that a whip is appointed at the instance of the political party and conveyed to the Speaker. That's conveyed to the Speaker. How is the Governor talking about the whip being Gogagle? He's talking about Gogagle being the whip in his communications. He's not concerned with it. That's a matter of the House.
Governor spoke of not
Gogagle. Gogagle being the whip.
spoke of leader of the house, right?
That also. How is he?
He was the whip,
I think also leader of the House.
leader of the house, Shinde.
Yes. Not how is he concerned with it? He is not there to appoint the leader of the House or to recognize. Yes. He says a purported appointment of Ajay Chaudhary is illegal. How is he concerned with this? See all this, the letter that he is sending to the Thackeray.
Governor's letter.
Yes. Governor is saying all this.
You're referring to
Where
para
is it,
3.
Arya?
Yes, para.
That is his letter to Uddhav Thackeray
Yes.
Ah.
Yes.
for holding the trust.
So why is he? Yes.
Trust
Correct.
board का कुछ जो letter लिखा
Correct.
था.
And he's saying all this. How is he concerned? And if they continue to be the Shiv, I'm grateful to your Lordship when your Lordship asked. If he is the Shiv Sena, then where is the loss of confidence? There's no loss of confidence then. What he's doing is he's recognizing 34 people to be a faction. And on the basis of that recognition, then determining that there should be a trust vote. That's what he's doing. The fact of the matter is, in law, he cannot recognize. And neither Bomai, nor Shivraj Chauhan, nor any of those judgments will come in the
The
way.
solicitor argued towards the latter part. He said that what they said in their letter was that we wanted to withdraw support from the MVA government.
Yes.
So he said this in effect was therefore a withdrawal of support to the government.
Let's assume, Malat. I will assume that against me. That can happen in any situation, Malat. Any 2 people, 4 people, 7 people, 12 people, 30 people can withdraw support. They may be members of the legislature. That is why the whole purpose, Malat, of the Constitution, Article 170 onwards, and to only recognize political parties, the whole purpose is that. That's why Kyoto says, Malat, that you don't have any other identity. Integrity of the political party and the political process. That's why. I will accept all that, Malas. That's exactly the Ayaram Gayaram test. That anybody can walk out.
The difficulty arises in an emerging situation. This is the question that's been troubling. In an emerging situation, suddenly during the process of the existence of the Legislative Assembly, there is this kind of a dissension. Take, for example, this very case. So what is very apparent so far as the House is concerned, 34 have come on to one side.
Right.
This doesn't definitely, there's no material that it reflects what happened outside.
That's right.
There's no doubt about that.
Yes.
But in a situation, perhaps is it possible, how does one, let us say the speaker, when such a thing is placed before him, would he also take into account or merely adjourn the case, asking the parties to go back to the election commission and get it proved?
Yes, but I was going to come. I was going to come to that. Let's forget this case. Let's take a case where people. I don't take for granted what that letter says on the 22nd, that the electorate is unhappy. Your Lordship knows, there's not a single instance of any of them making any statement prior to the 21st of June that anybody is unhappy. This is all their statement made, because they are now sitting in Guwahati and they know what the consequences. And they didn't go to Surat and Guwahati, on the 21st. This must have been pre-arranged, These things don't happen overnight. But be that as it may, I don't want to enter into the politics of it. But your lordship is right, Malad. It is correct, but that these things will happen. But what is to be done? What is to be done is, if you are a faction and you go to the governor will say, I can't recognize you. You want to say you are the political party, Malad? Now forget this case. You go to the election commission. You say you are a faction. I am the political party. Supposing you had gone to the election commission and done that, and then attempted to change, no problem. First, the commission would have decided. In the meantime, the disqualification petitions would have been heard. That's the constitutional. And don't connect one with the other. Then the disqualification would have been decided. Then they wouldn't have been able to go to the commission because you're deemed to have given up membership of the party. And forget, so there may be no dispute at all, Malaj. Why do you say there's a faction in the legislative party? There may be if two factions within the political party, each claiming that they are the party. Forget about disqualification. What's the procedure? Go to the election commission. Can the procedure ever be that you claim as a faction of the legislative party to be the political party, get recognition from the governor, topple the government, then go to the commission and say, these are the 36 or 38 members of the legislative party. We are dominant in the legislature. Now we must get the symbol. Cannot be. By any standards of constitutional law, this cannot happen.
What happens in the interregnum?
Sorry?
What happens in the interregnum?
Suppose
the speaker takes a prima facie view and says that go to the election commission and come back to me and tell me who actually is the political party.
Normally, the speaker will not do that, and with great respect.
Then he proceeds with 10 schedule.
No, yes, he'll proceed.
Then all the 34 will be disqualified.
Yes, why not?
No, I'm just asking you.
Yes, but they will be.
So therefore, that's the consequence.
Yes, they will be. Let me tell you, Lord, this is also a very other important aspect of the matter.
With the advent of 10th schedule in a situation like this, where more than 3/4 of the legislators have, let us call it not a split, let's call it a faction in terms of the symbols order.
It is a faction.
Symbols order. Let us call it as 3/4
yes.
are in one group.
Yes.
Then in which case it's an inevitable consequence that the faction which is in control of the government would have the speaker with them and would disqualify them.
Yes.
There is no other alternative according to
you. They can't be, Malas, for the reason the third paragraph has been deleted. The whole purpose of it is that you cannot have, see, they will still be disqualified for their acts for having voluntarily given up membership of the party.
It was 1/4.
Even if they are the party, Malas,
it was 1/4, Mr. Stibble. That's why I was asking them repeatedly.
1/3,
yes. Right? We are talking of a 3/4 situation.
Doesn't matter, Malas, because 1/3 could have been 2/3 also.
Isn't there a difference between split and overwhelming majority of legislatures?
No, that's not recognized by the 10th schedule, Malas. The 10th schedule doesn't recognize it.
What does Quixote say about it?
No, Quixote doesn't say either.
About it.
Quixote doesn't say either, but Quixote doesn't talk.
I want you to just help us on this.
I will. Tomorrow I'll help you. But just one.
This is something which we.
One last thing I just wanted to mention, Malas. That. Anyway, we'll do it tomorrow. It's better.
Sorry?
We'll do it tomorrow, Malas. It's better. We'll do it tomorrow.
Will you give a thought?
Yes. I've now given your lordships, Malas, in the entire argument. Now it won't take very long. Obliged.
And that prima facie stand that they have argued, that also just tell us about that. Just tell us that work.
Sure. Deeply.